City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear requests for variances and exceptions from the regulations in the zoning ordinance. We have the authority to hear conditional use permits and appeals from the decision of the staff and the administration of the zoning ordinance, and to make decisions in such matters. This is an open and informal meeting and is being recorded. The board members have received a copy of the agenda and the staff reports and recommendations. Copies of the agenda and the staff reports and the recommendations are available for the public in those two bins right to the left of the door as you come in. Today we have the board member, Brooke Rosenberg, Cindy Smith. I'm Tom Clark Sr. To my left is seated Michael Kelly, legal counsel. Bill Gray is on vacation. He usually chairs these meetings. Linda Westergaard is to my left, Mel Pins, and Jay Christensen. The staff today is Eric Lundy, city planner. Bert Drost is on vacation, I believe. Sue Donovan, is she here today? Yeah, she's in the back there. Sue Ann Donovan. Jason Van Essen is here. And Emmanuel Toribio is also here. Michael Ludwig is our planning administrator, but he is not present. The board's required to base its decision in each case upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff reports. If the facts as determined by the board demonstrate that the criteria established by law for granting the relief have been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. All speakers are requested to focus their comments upon those facts that demonstrate whether or not the criteria established by law have been satisfied. Each appeal will be announced in order, and the staff will present a brief explanation of the appeal. Any written comments received by the staff prior to the hearing will be distributed to the board or otherwise identified. All speakers are requested to speak from the podium and to start their presentation by giving both their name and address. The appellant or representative of the appellant is allowed to speak first and will be allowed 10 minutes to present his appeal. Anyone else present in support of the appeal will then be allowed 5 minutes each to present his or her comments. Anyone present in opposition to the appeal will then be allowed 5 minutes each to present his or her comments. The applicant will then be allowed 3 minutes for rebuttal or other closing comments. The meeting will then be closed to the public comment and the board will make a decision. The decision and the reason for the decision will be announced. Items listed on the consent portion of the agenda will not be individually discussed and will be considered for approval in accordance with the recommendation in the staff report unless an individual present or a member of the board requests that the item be removed from the consent agenda and separately considered under the public hearing agenda. The decisions of this board can only be appealed to the Polk County District Court. If you believe you've been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the city council to change those regulations. All material, written or otherwise, used today as part of any presentation will become a permanent part of the record and will not be returned. Cell phones tend to be disruptive, so we ask that all cell phones be turned off or turned to silent mode. There'll be a short break around 3 or 3:30 if needed. Now, with that, I'd ask the staff, do we have any housekeeping matters?
There was an email that was passed around for item 16. Anderson at 5112 Southwest 9th Street is requesting continuance.
All right.
They want to take a little time to see if maybe they can position their proposed patio in a different spot on the lot that might be more agreeable. So they're asking continuance for a month.
Is there anybody here to speak in opposition to item 16? Is there anybody here, because the applicant has requested a continuance, is there anybody here to speak? Yes, ma'am.
Rebecca Anderson, 5112 Southwest 9th, Des Moines. I'm the applicant, and I requested the continuance.
Okay.
To next month.
To next month, please.
July 25th is the next meeting.
All right. Do I hear a motion?
So moved.
Okay. Second?
Second.
It's been moved and seconded that item 16 be continued to the next regularly scheduled meeting on July 25th, 2012. All in favor signify by saying aye.
Aye.
Opposed? It's continued.
Thank you for your time.
All right. On the agenda, items 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10, and 11 are on the consent portion of the agenda. Is there anybody here that is appearing to object to any of those items? Yes, ma'am. Which one? Number 9. Okay. All right. We will then hear item 9 in the regular portion of the hearing today. Is there anybody else that's here to object to any other items 1 through 8 or 10 and 11? Yes, sir?
The wastewater plan for the Newton Avenue.
That's not on the consent.
That's not on the consent agenda, okay? All right. Anyone else? All right, I'd entertain a motion on the consent agenda.
Mr. Chair, I'd make a motion to approve the exceptions, variances, and special permits requested on the consent agenda, subject to staff recommendations, which includes items 1 through 8 and items 10 and 11.
I'll second.
It's been moved and seconded to approve the consent agenda as amended. All those in favor state by saying aye. Aye. Opposed? The consent agenda passes 6-0. If you are here to appear on items 1 through 8, 10, or 11, those applications have been passed, and you're welcome to stay for the rest of the meeting, but thank you very much for coming. Because the item 9 has been moved from the consent agenda, it will be the first item to be heard. And city staff will first make a presentation on item 9.
Mr. Chair, and we did not get any, I'll just show you the consent map first. We did not get any response cards for this.
Okay.
This is a request to configure the lots in this location. We're talking about a property on the west side of East 40th Court, just south of Easton Boulevard, and this is in the Grays Woods neighborhood area. The property in question was combined over time, but is a vacant parcel as a whole. The appellant is seeking to redivide into 50-foot wide lots to allow construction of single-family dwellings. This neighborhood was originally platted with the 50-foot lot configurations. There are examples, as you'll see, in that surrounding area where there's been other combinations of property. But there's certainly probably a higher percentage where the lots have stayed as 50-foot lots with single-family dwellings. So staff in this case is recommending in favor of it. We do want to make sure they've given us a concept of the type of dwelling that they're wanting to put, which is a split foyer type arrangement. This would be the front elevation that would face the street. So you get an example of the kind of materials, and I can pass that around if you're having trouble seeing the small print if you need to. Our concern from a staff perspective was that we didn't want to repeat the same treatments on the outside of the house so that they looked identical. We were just wanting to make sure that there was some variation in some of the exterior materials to the point where they didn't look like two tract homes that were being put on these vacant parcels. So we're recommending in favor of it, subject to that, basically that condition, and obtaining all the necessary permits for any construction. Are there any questions?
Okay, is the appellant here, representative of the appellant?
I'm Jason Shootman, 2018 East 40th Court. And we're proposing to build two houses, and as far as the facade on the outside, we would do something different to differentiate that two houses from each other. There are several other split floors in the area and on the street. And like I said, most of the lots are 50-foot lots already, as this one was a 50-foot lot at one time, and it was combined into a 100-foot lot, and now we just want to split it back up. That's all. Thank you.
Any questions from the applicant? Yes. Okay.
Jason, do you have a provision for a paved driveway for each of the properties?
Yeah.
Okay, and any provision for a garage at this time?
We haven't checked into that.
Okay, all right, but you're going to have a driveway on
Yeah,
each lot? Okay,
correct.
thank
Yep.
you.
Jake?
What is the exterior material on the front face of the house?
It'll be like a hardy plank siding, wood siding.
Okay. And then what about the sides? It looks like it's different.
Well, actually, the front of the house would be like a kind of like a shingle shake, just on the front two peaks, each side of the door, and then the rest of it would be like a hardy plank siding, wood
Okay.
siding.
Any other questions? Thank you.
Thank you.
Anybody else to speak on behalf of the applicant? Anyone to speak in opposition?
My name is Karen Shupman, 3804 Indianapolis Avenue, Des Moines, Iowa, and I'm chair of the Grays Woods Neighborhood Association. And our neighborhood association was not aware of the proposal to divide the property located at 2018 East 40th Court into two 50-foot lots until Bob Mahaffey and Councilman Skipmore brought it to our attention. On June 13th. I received the notice in the mail on June 15th. The nature of the Grays Woods neighborhood is to have lots from 60 to 64 feet at least wide. And in order to make the determination, I need to bring this before our next scheduled neighborhood meeting, general neighborhood meeting, which is August 7th. So therefore, I'm respectfully requesting that the item be continued so we can bring it before our neighborhood association.
Okay. Is there any questions?
Mr. Chair, I might just have one brief one. You do have an executive board for your neighborhood association.
Yeah.
Was it possible for you to call them and gauge any kind of a general feeling or consensus?
Yes, I can do that.
No, did you do that?
Oh, no. I have been out of town, and several of
Okay.
our other board members have been out of town, so we just
Okay.
haven't had the time.
Okay.
But, we can surely do that.
Okay, thank you.
I have a question. I'm not sure if it's for Ms. Shootman or the city staff, but was a notice sent out to the neighborhood association?
Yes, they get a copy of the full agenda sent to them.
Okay, so it arrived later than,
We got it on the 15th, I got it on the
That would have been the
15th
normal timing.
of June. So-
Okay.
I mean, the applications come in 28 days before the Board of Adjustment meeting, and then we process those and create the agenda, and then we send out the notices, and it's really only about 2 weeks ahead of the meeting when that gets mailed out. So
Right.
that's about as soon as anybody would expect to get it.
Yes, I have a question. Has this issue come up before with the Grays Woods neighborhood, where someone wants to take a lot that's been combined and then restore it to its original configuration?
Not that I have been notified of.
No, I mean, while you've been a member of the Grays Woods Association, this has never occurred before?
I'm not quite sure
Okay.
if it has or not.
All right. Thank you. Is there anybody else to speak in opposition?
I don't have any, I can send you one later.
Okay.
I don't have any names right now.
Okay, we'll close the public hearing and go to board.
Mr. Chairman, if I could just say, I do know the applicant. I've not seen him or talked to him in probably 7 years, but I just wanted to make it known that I do know him. At least I think it's him. It looks like him.
I'm sure that.
And?
But I just wanted to
Oh,
make, I just
you're
wanted
just
to
saying
make that aware. I
okay.
didn't want somebody to come back later on and say, oh, I had a conflict.
I know lots of people that appear.
I do too. I do too.
Okay. Is there any discussion here? Does anybody have anything to say about whether the continuance ought to be considered or not considered?
Well, I think the applicant has to ask for the continuance.
I think he does.
So is that the only discussion that we're having right now?
No, I want to.
Well,
We've granted plenty of people 50-foot wide lots in Grace Woods and in other infill lots, and we've done it happily because we want to see new housing there. So I would, my vote would be to make a motion to move staff recommendations. I don't see any reason why not to.
All right.
I would second that.
Mr. Chairman, just to give some credence to the speaker, I'm a member of a neighborhood association myself, but all the neighborhoods are noticed, as Eric explained, and some neighborhood associations meet monthly, some meet bi-monthly, some meet quarterly. We can't necessarily put our schedules for our decisions on the time frame of every regularly scheduled meeting of a neighborhood group. If they receive information they're concerned about, I suggest they get together, maybe have their minutes might allow, or their charter allow them to have an ad hoc meeting, and they have an obligation to get in here if they got a concern. So I think the applicant presented himself pretty clearly on this, and looks pretty good.
I'm presuming that the applicant does not wish a continuance. Is that correct? Correct. Okay, it's been moved and seconded to approve the division of the lot. All those in favor signify by saying aye.
Aye.
Passes 6-0. All right, the next scheduled item is item 12, the Wastewater Reclamation Authority. And there is an additional, or there is a copy of a letter. We may have had it last.
Yes, Mr. Chair. This is a continuation of the item that was at the last meeting of the Board of Adjustment. At that time, a number of concerns and questions were raised about the construction project for the pump station that was being proposed in this location in the Frisbee Park area, just north of the Raccoon River levee. And then at least one neighbor expressed concerns that you wanted to be readdressed. The Wastewater Reclamation Authority put out a number of notices. They basically noticed from Gordon to Railroad, east of 63rd Street, to the area where the pump station is. And I'll let them describe how many mailings that was, but they conducted a separate meeting to present the project and then entertain questions and issues. And that's outlined in the notes on the last page of your packet there that was presented. The letter from Veenstra and Kim is a response to a number of the issues that were specifically raised at the board meeting last time. I believe a number of people are here today that will be able to ask or answer any of those questions or follow-ups to any of those issues and questions. Let's see, we have Dave Miller in the back here, Scott Hutchins to my right, and Bob Veenstra from Veenstra and Kim. So people that are very close to the project that can answer specifics about this project. We're keeping the same staff recommendation as previous. We haven't altered that, although I think you will note in the communication that there are a number of measures being taken to, as part of the project itself, that are that would alleviate a number of the concerns that were raised.
All right, thank you. Does anybody have any questions of the staff? Okay, applicant or representative of the applicant?
I'm Scott Hutchins with the Wastewater Reclamation Authority, 3000 Vandalia Road. As we talked last time, the board had a number of concerns, and we addressed those concerns. One of them was to have a public meeting. We sent out almost 350 letters, and we had a public meeting of about 5 people attended, 5 residents attended the meeting, and that was held on June 20th. Bob Veenstra and Kim went through the entire project, had a number of displays and panels, and talked about the project. And I might have him come up and talk about the project as well. I don't know if you received the document that Eric was talking about. There was a number of questions. There was about 4 or 5 questions from the audience that we addressed. One of them was, is there a possible provide access to the project down Railroad Avenue off of 63rd, basically along the levee? There is room there, but it's and that's right along here.
If you'll move your head back a little. Thank you.
Right down this is the bike trail here, and then they asked about access coming down here and through here, which there is room through there, but it's we'd have to build a road. That would be very cost prohibitive to do that. We'd have to put rock down in case it got muddy, and you'd really tear up that. The preferred route is to be accessed down Winona, a paved street, rated for regular traffic or residential traffic. We would, before the project, take any pictures and document that road and videotape that road, and if we do damage that, we'll come back and repair that road to get it back to the condition it was. Another thing, one of the people that was at the meeting lived right here. He was opposed to having that road in his backyard. I know Mr. Acella, he lives here. He was in favor of having that road go down the back, but it's just cost prohibitive to us to do that, and we do have an access coming down Winona. We think that would be a better way than going through those people's backyards and tearing up portions of that and then have to come back and restore all that. They asked, when was the project originally planned? It was part of a facility plan that was submitted by the WRA to the DNR in 2003. This is part of a bigger project, just not this small portion where we actually take this water during high flow events and pump it down to a holding facility of 450 million gallons down in Norwalk. That plan was approved by the DNR in 2004 and then adopted by the WRA board in 2004, which Des Moines is a member of the WRA, and approved also and voted in favor of moving that project forward. One of the residents asked if the project would cross the levee, and if it went through the levee, how could they be sure that they will not be protected from flooding during construction of the project? Over here is actually, we go over the top of the levee. We don't go through the levee here, so we're over top of the levee. Over here there is a smaller levee which we will go through, but there is stipulations in the contract in case that during flooding times the contractor has to stage material there to be able to close that levee, given notice by the city of Des Moines or the WRA to close that levee back up. So they will continue to be protected there. And this project has been submitted to a number of folks, the IDNR, the Corps of Engineers, and it's met those approvals. How is the project paid for is one of the questions, and it's paid for through the 17 member communities based on a number of criteria as far as how much flow they contribute and if they're an expansion community or a core community. And basically it's paid through, and that money comes from sewer user fees from the residents or the people that are served by those communities. The same question was, will my sewer rates go up? And Dave Miller explained to the lady that asked that question that the sewer rates are planned to go up at 9% for the next 2 years, not just because of this project, but of other projects and other things going on in the sewer system. So the sewer rates are going up. Is it because of this project? It's part of this is some of the, from this project. The city of Des Moines has to pay for their portion, but there's other projects involved and other costs involved that's causing the sewer rates to go up as well. Bob, I don't know if you wanted to.
Yeah, go ahead. Mr.
First of all,
Hutchins, if you'll wait a second.
Thank you for having the meeting. But if I recall, when you were before us last month, one of the neighbors asked about noise and smell. That wasn't addressed when you had the neighborhood meeting?
It really wasn't brought up. I guess we forgot to bring it up. It was Mr. Asilla was at the meeting, and we talked about numerous things, but maybe Bob can address.
Well, I know it's addressed in the engineer's letter, but it never got brought up at the
No,
meeting.
they never mentioned it. There were the 5 people over there never talked about. Mr. Asilla might have said something about the noise or the construction noise, but other than that, I don't recall.
Well, it just surprised me when I saw your note. Okay. All right, thank you.
Go ahead, sir.
Bob Veenster Jr. of Veenster and Kim, 3000 Westtown Parkway, West Des Moines. If I might follow up, Mr. Rosenberg, on your question. During the presentation at the public meeting, I addressed those 2 issues. I indicated that the pump station is fully enclosed, so it has very little noise. There are 2 standby power generators. We located them to the east of the building, so they'd be the farthest away. We're also including soundproofing enclosures so that those generators, when operating, would generate 72 decibels at 23 feet. And when we gave the presentation, there was a dance class going on in the next room, and we noted that it was probably less noisy than what we were competing with the dance class. I also noted that with respect to the pump station itself, it's operated only intermittently, and so we included provisions so that when it's not in use, that we can pump out all the water so that it's essentially evacuated and there's nothing there. The other thing we did is that the force main for this, it's not directly related to this, but it's a long force main, and we included provisions rather than just filling it in the spring with sewage. We're actually going to purchase finished water from the Des Moines Water Works in order to finish it, fill up this main, so we even further reduce the potential. So although there were no questions asked at the public meeting, we did address that during the introduction to it.
Does anyone have any questions of Mr. Veenstra? All right. Is there anybody else to speak on behalf of the applicant? Okay. Is there anybody here who would like to speak in objection to item 12? Yes, sir. Come forward. State your name and address.
My name is James Acela, A-C-E-L-A, and I live at the end of 5708 Winona Avenue, and I always have. And my concerns are pretty much the same as they were a month ago, that it's going to be terrible noise. It's going to destroy the foundation of my house and probably others. And it will not be any kind of permanent solution. You know, I've lived through similar things before, and that's how I know that the foundation is going to suffer from this. I took a couple of notes that I would like to comment upon. At some point, I was told that this pump station will not run during times of no high water, and that it would not run at all so far in 2012 because it's been so dry. But I have a pump station behind me right now that was completed in 2000, and it runs every Tuesday right before 1 p.m. for some reason. It runs for about an hour, rain or shine. So I think that this new one might do the same thing. And then the comment about driving through people's backyards, that was actually my suggestion to bring their trucks, if this is going to go ahead no matter what, to bring all the cement trucks behind Winona. And there was some remark made at the meeting a week ago that, it would be better to go down Winona than to go through people's backyards. It's not people's backyards, it's city property. And the lots go back almost an acre from the street. And then the city property is beyond that further south. And I think that would be preferable to having the cement trucks going all day in front of people's houses, just feet from their front yards. That's basically all I could say at this time. I know that this is not going to be the solution that everyone thinks. And so, I'm still against it for whatever that's worth.
Thank you.
Thank you.
Is there any questions of Mr. Aslan?
I have a question. How many cement trucks are going to be coming up and down the street? I mean, how much cement are we talking about?
I think that maybe Mr. Scott Hutchins could perhaps answer that question.
Over an 18-month period, there'll be about 500 cement trucks going through there.
And how many would that be a day?
Well, it
Do
depends
you have
on
any
how-
idea?
No, we really don't have an idea because it's based on how, we're not the contractor, so how he stages his work. If he has a cement truck uses about, can haul about 10 cubic yards. I mean, if they had so you can figure it from there, if they had a 500 cubic yard pour, that would be 50 trucks, but we don't know how many trucks in a...
Yes, but that wouldn't it have to cure before you put more in? Or?
Well, if they have a huge pour, though, sometimes, out at the treatment plant that we're building right now, we've had pours where they're, hundreds and hundreds of yards at a time where they'd pour a large amount of concrete in a day. So, but it's not going to be every day. It's not going to, but it's, when they do a pour, there's going to be some trucks coming through there.
How many trucks will it take to bring the dirt out? I mean, I would think you're taking more dirt out than the cement you're putting in.
If I might answer the question, there will actually be no dirt taken off the site. What we're doing, if you look at the grading plan, we're actually building this up above the ground elevation. What we're trying to do is build this station actually higher than the levee, so that in the event, we don't plan on it, but in the unlikely event that we had a levee breach, we couldn't maybe say that the pump station would still be in the dry. So all the dirt that we're digging out of the hole, we're going to stockpile and then build up. So although there'll be concrete coming into the site, in this particular case, we will not have dirt going off the site or bringing it back in. So there'll be less trucks than if we did take the dirt off. And that was a decision that was made, that the WRA has really contemplated what we need to do to flood-proof our facilities, and raising this about 10 feet above the natural ground elevation seemed to be the prudent thing to do. It provided us some flood protection. It also reduced the amount of construction traffic that we generated as part of the project.
And I can't remember last month's conversation in detail, but it seems that the neighbor had said that they had suffered some foundation problems before when some things were being done. And I know that, 500 dump trucks plus everything else is probably going to put some damage onto the street. And I heard you say, take pictures and do things to make sure that that happens. Is there anything that you can do for the homeowners to come and look at their foundations and say, this is the way it is today? I mean, that is a tremendous amount of drilling that you're going to be doing.
A couple of things. Most of what we understand to be the construction impact from the original project was that the way they built that project was they drove steel sheeting down, and they were intended to drive it down to the shale bedrock. There is a bunch of boulders and cobbles that are in the bottom of the sand, and they spent a considerable amount of time trying to drive that sheeting down through the boulders. And I think a lot of the construction vibration occurred as a part of that. We will not be using that construction procedure. They will be digging it in open cuts, so they'll go in like with a scraper and dig it away. So we're not going to be pounding the sheeting down to the bottom. We'll still have to take the shale out. There'll be one little area where we'll have to do sheeting where we make a hole in the round tank in order to protect it. So we're using a different construction procedure to try to alleviate that. We do have vibration monitoring or seismic monitoring that will be there during the project. That will not only record the acceleration of the earth from what we see from the construction activities, it'll actually pick up vehicles. If you're familiar with the cross at 100 Court Avenue, where they're building the stormwater pump station, we used vibration or seismic monitoring there, and we were able to pick up not only the construction equipment, but every time a heavy truck or an 18-wheeler went down Court Avenue, we could pick that up. So we'll be able to see what vibration or what soil vibration that we have from that. We would also be glad to inventory and make a record of anybody's property in advance of construction. WRA currently has a project undergoing down by Crevero Park at Southeast 14th and Railroad. We're going up Southeast 11th, and there we asked every property owner, would they like us to come in and make a record of their property in advance of construction. We don't actually even look at that. We seal it so that we're not biased to what it is, so that if they make a claim later on, we have an independent record. Somebody can open it up and say, here's what it was in advance. So it's sort of a blind record of what it was. The property owner can see it. We will not look at it so that we don't have a preconceived idea. If any property owner in this area would like to have that done, we're more than willing to do it. We can't force it on people, but we're doing it, say, on Southeast 11th and Vale Street as a voluntary program, and we've had so far, we're only on the first street, and out of the 5, all 5 have volunteered to do it. So we'll be glad to do that.
And what happens, my last question is, what happens if we get in the middle of this project and the neighbors are having concerns? Is there somebody that they can readily contact?
Yes. We'll give them several contacts. They can contact Nick Carter of the WRA. His number is in all the information that we gave out for the public meeting. They can also contact our office, and our information was also on that. And anybody that wants to know, we'll give the on-site inspector's cell phone number out. So if they have a short-term issue, it's like, it's really bad today, can we see if we can calm things down? They'll have a cell phone number as well as some office numbers to get a hold of. So we have no problem with giving people out the information so that either as a longer term or a shorter term issue, if they've got something, we'll be glad to try to follow up with that.
The neighborhoods are very important. Everybody who lives in Des Moines, they're stakeholders, and it's important that we preserve their neighborhoods. What happens if your project doesn't get approved? What kind of an impact does that have on us as residents?
If the project doesn't get approved, we have a negative impact on not only the western part of Des Moines, but the western suburbs. The main sewers that come out of what would be the West Des Moines, Waukee, as well as the Cummins Parkway up into the area of Merle Hay and Urbandale Avenue, all come down along Walnut Creek, and they join sort of at the confluence of the Raccoon River and Walnut Creek. When we get into rainy periods in the spring, we have more water than we can handle, and the sewers back up. And one of the areas that's most adversely impacted by that is the Frisbee Park area. The pump station that Mr. Osello referenced earlier was built a number of years ago to try to recognize that when we get too much water in the sewer system, it can flood the sewers in Frisbee Park. So the city put that in as an effort to try to isolate that area from the larger sewer system. What we're doing with this project is that we're trying to take the sewers and isolate it so we not only improve the Frisbee Park area, but also handle the overall area. So this is one piece of about a $120 million project that's designed to intercept about a quarter of the water that would go to the wastewater plant, take it off and put it into storage. So if we don't have this, we impact not only this area, the western area. If you look at the Southeast 9th and Jackson area, some of this East Hartford area, all those sewers back up because they back up all the way from the treatment plant all the way along the river. And so what we're doing here is saying we're going to take a goodly piece of that water, about 100 million gallons a day, and we can pump it over and store it. So just for a frame of reference of how much water we can pump, if you're familiar, I'm going to use one out in West, if you're familiar out with a water tower that's out by Valley West Mall, it's 1 million gallons. This pump station can fill it up in 15 minutes. And the storage volume that we're pumping this to is 45 times as large as what we have here. So the little one we have here just sort of is, was the estimate back in 1982. We recognize there's far more water that we need to store, and so we're building a much larger facility, much bigger ability. So it is a broad region that really affects everybody, not only in Des Moines from about Southeast 30th and Vandalia up along the river, but then out into the suburban areas as well. So it's a very broad implication if this is not constructed. So,
Thank you.
Are there any other questions for Mr. Veenstra? I have one question, Mr. Veenstra. If Mr. Acela wants his property inspected so that a determination can be made as to whether this project affected his foundations, who does he contact first? You or Dave Miller or Scott Hutchins? I mean, is there an order?
He can contact myself or probably Nick Carter. So my phone number is 225-8000, and Nick Carter's is 323-8135. So either one of us, or if they're not able to get us right away, one of us will get back to him.
Okay.
It may be a little while before we inspect it because we're not ready to start construction, but we will be glad to do that in advance of construction.
Okay. Thank you. Are there any other questions? Okay, we'll close the public hearing and go to review by the board.
Mr. Chairman, one of the key items that we have to look at in approving a special permit is that the proposed location, design, construction, and the operation of any use we want to approve, it has to be designed to safeguard the health, safety, and general welfare of people who live in and around the area. And from everything presented, that's exactly what the project is for. A lot of times somebody wants to do a use just because they want to do it. And we have to ensure that it meets these criteria. This is why they're designing the project, so that they can help Frisbee Park and help deal with this area. Frisbee Park was basically built in a floodplain. So it's hard to get water out of there. I think that the Wastewater Reclamation Authority and their consultant, I mean, these guys are engineers, they're professionals, they've got the experience with this, they've shown us other projects where they have had much closer operations and they showed no negative effect. I think they'd be willing to work with Mr. Acela and anyone else on Winona, as you kind of alluded to. I think they've made design guidelines in here with landscaping and setbacks. You know, we live in a city, we have to have public utilities. So I don't have any problem with this, and I would recommend the staff recommendation for approval.
Second.
It's been moved and seconded that the project be approved, subject to staff recommendation. All those in favor signify by saying aye.
Aye.
The project passes 6-0.
Okay.
All right. The next numbered item that we are on is item 13, Scores Sports Bar at 2335 Hickman Road.
Yes, Mr. Chair. This item was continued because at the time it was only about the consideration of the zoning officer's interpretation of the previous order for their conditional use for their outdoor service area, which was a determination that there would be no outdoor sound. And therefore, a request was not accepted when they sought a temporary sound permit for a event that they were planning to hold, or that they held. And the appeal then was made to get a determination as to whether that was a valid interpretation. But there was no additional item then, if the interpretation was upheld, that would have allowed the board at the time to consider amending the conditional use to allow sound. So that was notified for this meeting, as well as the previous appeal. So it's now in front of you in two parts. The original request, in addition to another appeal for the amendment of the conditional use, if you do uphold the board zoning officer's decision. Staff then also considered the amendment consideration for allowing any outdoor sound. In reviewing that, our concern, again, is the proximity to the neighborhood in this case, and so we are still maintaining a recommendation that you not grant outdoor sound. If you recall, we also were concerned at the time of the original conditional use for the outdoor service area. So again, based on the proximity with residential neighbors, we didn't think it was appropriate.
And do you have that map? Because don't we have like a school close by, or?
There is the Freedom for Youth Ministries nearby. It probably doesn't qualify as a school or a church. It's really a vocational program. So that property owner did express concern about the proximity. But in terms of it, there actually being a school within any type of separation, that isn't an issue here, or that isn't an appeal that they're making. It's not a separation consideration.
Eric, the current status is that they have a liquor license, they have a patio, they can serve on the patio, but they can't play music on the patio. Is that pretty much?
Right. The interpretation is that there's no outdoor music, and let me see if I can find that original order.
Yeah, according to your notes on page 28 of the staff reports and recommendations, it says that we granted the expanded existing tavern use, but there was a prohibition of any outdoor music or amplified sound on the patio. This is the order. Okay, hold on a second.
Let's see, I think I have the right one here. Nope. Let's see.
Because we're,
Yeah.
how does that square up with what's in our packet, Mr. Chair, which, is that what you're getting at?
No, he's got the original order here
Okay.
before us on the screen.
Oh, it's up there in the bold print at the top.
Right.
Our condition 1.
Question. I'm not clear on why we're back here. I thought that we discussed in that meeting that,
You did discuss it, but you had no ability to take any action then to remedy the applicant's
I thought
request, which was to have some music, because if you upheld the decision, the matter was
my
had no further consideration.
recollection was there was some discussion about a event, sound event permit, and I think the applicant said they would be doing 2 or 3 of those a year.
Correct, and the zoning officer was still saying that would not be allowed under this previous order. And so the board was faced with either we have to say that 2 or 3 events wasn't really the intent of this, or we would have to re-notify to allow you to amend to allow 2 or 3 events.
There we go.
Brooke, the item is before us because the applicant disagreed with the city's interpretation of this order. She thought that it meant no continuous music on the patio, but that she could apply for a special application for certain events. And our city officer said, no, you don't get any music ever on the patio. And that was...
Well, but my recollection was that it wasn't just special events on the patio, it was special events in the front of her building, which was the parking area. It didn't apply to the patio. And it was my recollection that the special events were going to be 3 or 4 times a year, like the Drake Relays, a neighborhood fundraiser for the school, And now we're back here
Well, and
talking
that is
about the
correct,
same
but the
thing.
board was not willing to take a vote to reverse the zoning officer's decision on that, just on that finding. So there apparently wasn't enough votes to make that go ahead, an interpretation such as your.
Well, we decided to
discussing.
continue the matter, and that's what we're discussing right now. Is there anything else that staff has to add?
No, I think that we'll leave it simple.
Okay. All right. Applicant or representative of the applicant?
Hi, Julie White, 201 3rd Street in West Des Moines. Nice to see you again. Just basically, you guys pretty much summed everything exactly what I'm asking for. Just the 3 to 4 events a year, not on the patio. Patio's really small, if you remember. But outside events in our parking lot, such as the Drake Relay weekend. We'd like to do a community event, such as a potluck of the neighborhood. Since then, we have joined our neighborhood association in Prospect Park. We are doing, in conjunction with them, with the National Night Out, we are providing the food and doing some activities with them. So we've inserted ourselves within the neighborhood, tried to explain what we're doing at our location and the ideas that we want to do for the special events, such as Drake Relays. So hopefully, I don't think I received any.
No, there wasn't any, we didn't get any, we did re-notify it and there wasn't any response.
Thank you.
And that was a big concern of yours last month, and mine, for the re-notification, because they might have some confusion there. But I did go to the neighbors, went to the neighborhood association, so hopefully that has been cleared up and we're all on the same page.
And that is the consent map there.
Correct.
All right.
And that would have included the notification of the consideration to amend
Yes.
the conditional use.
All right. Thank you. Is there anybody else to speak on behalf of the applicant? Is there anybody here to speak against the application? Then we'll close the public hearing and go to board consideration. I think we ought to handle this in 2 parts. Perhaps we can discuss it all at once, but any motion ought to be, number 1, whether or not we uphold the deputy zoning officer's determination that temporary sound pit permits would be prohibited, and the second part of that would be whether or not we amend the conditional use to allow music a limited number of times a year, and if so, how many times a year, and where would that take place, that kind of thing. Okay, with that?
I would, the way I think about it is that I think I would want to uphold the zoning enforcement's decision that no music would be allowed. But then I would consider, I would be in favor of amending the conditional use permit to allow maybe 4 events a year or 5 events a year. Figure in the winter, we're not going to be out there anyway. But if you've got Drake Relays and National Night Out, maybe a back-to-school event, those are kind of what my thoughts are.
Anybody else? Go ahead.
Mr. Chairman, if we go back to the original meeting, when we had this in March, I think all of us will recall we had a big discussion about the parking lot, as Brooke had referenced, from the perspective that it's a long, deep parking lot. So the noise on the patio, if there was to be any, we didn't want any outdoor music or amplified sound on the patio, as the restriction states. But we felt that parking lot gave us enough of a buffer between the sidewalk and little kids walking home from school, neighbors, etc. Nowhere in that discussion were 3 or 4 events a year brought up, Drake Relays, or temporary sound permits. In fact, I didn't know that was in our venue to discuss that. So to kind of lay a little bit of blame on maybe both parties here, I think what the zoning enforcement officer heard from us is we were concerned about sound. We certainly were. But I think we were concerned about sound from the patio because the appellant did not tell us in March when we approved this that they wanted to do stuff in the parking lot. I might have sat back and thought about that. So I see Sue Ann's, with her statement, hey, it was our intent that we don't want any sound coming from the whole place. I can maybe see that, but in fact, with the 7 conditions that we approved, we roped ourselves in a corner. It was a prohibition of any outdoor music or amplified sound on the patio, the word ON. So, this is what we approved. So Julie's using that to say, hey, that's all you approved, so that's all I have to comply with. Now, had she told me in March she wanted to do more stuff, I might have said, wait a minute, let's talk about this, but she didn't. So I feel that we can't uphold this zoning officer's determination. She's trying really hard, but I don't think we got into those issues at that time.
I would respectfully disagree. I mean, she told us all about those events when we were here in March.
She did.
Yeah.
Perhaps I forgot or I don't recall that because had that been the case,
she
I
even
might have been more
had pictures of how she was setting up some of the tents and et cetera. I mean,
well, the Drake relays
do you have
hadn't
the
happened
minutes?
yet.
She did in May.
Oh, in May.
March was the original approval.
You said March.
No, I'm with you there, but that's why I said, Brooke, at our original meeting.
Original meeting. My fault.
And I chastised her a little bit that, you knew Drake Relays was a month away when you were in front of us, and you didn't bother to mention you might want a permit. So I see what Sue Ann's trying to do, but that's why, again, I feel like the way that we did this, perhaps we should have said you can't open the door to your business and blare the music out the door, because we've seen that happening too. It's hard for us to develop every angle here. She wanted a patio. We just said you can't have any sound on it.
We know what she wishes now, and
Right.
so I think it's more productive to focus on
And that's kind of what I wanted to get back
whether
to
we're
was-
going to permit 4 or 5 functions a year.
Okay.
And
But do we have to look at that part A first?
we don't have to do anything. But
Okay. She sinks, right? Yeah.
But your feeling then is similar to Linda's, that perhaps 4 or 5 events a year would be permitted?
If the board should consider Part B, I might be interested in discussing that, yeah. But I think, again, just by, practice rather than the principle of the thing, in practice, we roped ourselves into a corner. We only told her she couldn't have music on the patio. We didn't discuss or talk about any other bands. We didn't talk about music coming from the roof, from the dumpster, or from a temporary sound permit. We don't usually get into temporary sound permits here.
And what's your feeling, Jake, about this?
I wasn't here for the March meeting. I wasn't on the board then.
All
so-
fresh.
So it's all fresh. To me, I look at this and see a commercial corridor, and I think it's reasonable, in my opinion, to have some limited number of events.
Okay.
Because I look at this circle of notice, with the exception of the apartments right across the street, most of the rest of the uses are full-blown commercial.
Okay. All right. And Brooke, what's your feeling about the matter?
I would agree with you, Mr. Chair, and take it in 2 parts and vote on A and B. My feeling would be to approve B on the conditional use of what Linda said, I think she said 3 to 5 events a year. We may want to ask for a time frame on when how long the music would last. But I see nothing wrong with that.
And Cindy?
Yeah, I would tend to agree with and echo what Brooke said. I'm not sure 4 or 5, that seems like quite a few, so maybe 3 events seems reasonable, because if you take out the winter months, you're looking at maybe 7 or 8 months where you could have events, or it kind of almost sounds like summer events, or maybe one in the spring and one in the summer and one in the fall, or something like that, but
I know you're just not thinking of St. Patrick's Day.
And then we have relays.
I didn't thought about St. Patrick's Day. So,
All right. Then I'll entertain a motion on Part A as to whether to uphold the deputy zoning officer's determination that the previous order entered on March 28th of 2012 did prohibit the issuance of any sound permit for outdoor events on the premises.
I will second that.
No, I'm not making the motion. I'm listening for a motion.
That's the issue before us.
That's the issue.
Well, I will make that motion.
All right.
That we uphold the deputy zoning enforcement officer's determination.
All right.
I believe she did exactly what
What it said.
the order said.
I would second that.
All right. All in favor of upholding the deputy zoning enforcement officer's determination, signify by saying aye.
Aye.
And opposed? Okay. 5-1. We have upheld the deputy zoning ordinances, zoning officers' this determination. On Part B of the application, the amendment to the conditional use permit to allow the issuance of sound permits for outdoor events on the premises. Is there any further discussion that you wish to have about the number? About the number or the hours? Or should we allow the city to make that determination on a case-by-case basis as the event is presented to them for a permit?
I'm certainly comfortable with the city making that decision.
I don't want to micromanage it either. And I don't want to split hairs over numbers, but if you had 4, that'd be like 1 per quarter, starting St. Patrick's Day. It's March, still the winter quarter. And you got relays, summer, fall.
And this amended use permit, do you want to still bar sound from the patio?
I think I would. I think that was our initial intent in this whole deal. We were just dealing with, we don't want sound on the patio, and we don't want it there one day and then gone the next, and speakers that get put up for a temporary event on the patio, and then they don't go away. If you're going to put up a tent, and you want a temporary sound permit, and the city's okay with that, we've allowed up to 4 a year, work it out.
All right. Okay, and I'd entertain a motion.
Is the city okay? I mean,
And is the appellant okay? Can we ask if the, yeah, we know what the city
I mean,
wants.
can they manage it? I mean, is that something that
We
they want?
recommended denial just based on the proximity to the neighborhood. So, I mean, I think you just take it at that, and if you think a reasonable number, we'll work with that, and we'll follow the protocol for how we issue sound permits. And there's standards that are based on in commercial versus in residential, and we'll take that. The only thing I did hear was that if there is a desire for some kind of hours of operation for that sound, you might throw that in if you really think there should be a restriction on that.
I think there should be.
What would the city normally do for hours of sound operation in a zoning district as this?
Commercial's a little more liberal, that's why.
I mean,
Well, this backs up to an apartment complex, doesn't it?
Chair of Board, Sue Ann Donovan, Zoning Enforcement Officer. Are you talking about background sound, or are you talking about a sound permit?
a sound
For
permit, correct?
for the events in the parking
Yes.
lot?
Yes,
I believe in C2, they can have it until 10 or 11 on weekends.
okay.
That's what I.
So it's limited in the sound permit.
That's certainly satisfactory. We don't
I
have,
would be okay with 10. I think 11 is a little long.
On a Friday night during relays, come on.
What do I?
gotta get
The
out.
point I was trying to make is if you want to limit it from our normal requirements,
Yeah.
this would be the opportunity to do
Okay.
that.
Eh,
Okay.
I would also point out that if you deviate from the normal sound permits, it will be difficult for staff and police department
Yes.
to figure out what the hours are supposed to be. So I would urge you to stay with the regular sound permit time.
Let's just let them figure it out.
All right. Could I have a motion, please?
Mr. Chair, before we make a motion, could we ask the appellant Julie if she would be agreeable to no more than 4 a year?
Would you step forward? One of the board members has a question.
Julie,
Yeah.
would you be agreeable to up to 4 events a year and no more?
Absolutely.
Okay, thank you. Okay, all right. I'm going to make a motion to allow amendment of the conditional use permit to allow for temporary sound permits in accordance with normal permitting through the city's process with no more than 4 permits granted in a calendar year. And those permits shall not include any music or amplified sound emanating from the patio.
Do I hear a second?
Second.
All those in favor signify by saying aye.
Aye.
Opposed? Matter passes 6-0. Thank you.
Again, you know.
Item
Can't know what we
14,
don't know.
Jose's Floor Covering, Inc., 2803
Why I brought that up?
Southwest 9th.
Chair, members of the board, Jason Van Essen with the city's planning staff. The response card is being passed around. This is a map identifying the notice radius. We had 1 support, 1 opposition. Subject property is located at Southwest 9th at the intersection with Creston Avenue.
Okay.
This property has been vacant long enough that it's lost its grandfathering rights. You can see from this aerial that it's been paved, it was developed with paving up to the property line, not conforming with our setbacks. So there's, the part of the request is a variance of the 5 feet setback from the 2 street frontages for the parking lot. Then we also have a request for the variance of 15 feet less than the minimum of 25 feet for the dumpster enclosure, which would be located down here. Photograph of the property. I'll just flip through the pictures here. This is from Creston.
Would you show us the photograph and explain to us the access to the property?
Sure.
And whether it's a 2-street access at the present time or not?
Yeah, let me get, you can see better from this picture that it has 2 drive approaches that kind of, there's also paving in the right-of-way, so it kind of blends or blurs all together, but there's the one off at 9th and then Creston right here in the foreground.
And explain to us, while you're making your presentation, that you wanted to close one of those accesses, is the way I read your recommendation.
Yeah, and I actually have a sketch showing this, a staff recommendation.
Yes. So perhaps you could expand.
There is enough space for a 24-foot driveway to allow for 2-way access and circulation on site. But anyway, I'll just, so we have the pictures here. There's some grade separation variation from Creston to the site. Looking towards the north, down 9th, and then south, down 9th. This was a sketch that was submitted by the applicant. During our analysis, we found that the measurements are off. So they were showing, they're proposing to have no setback. They believe that they didn't have the space to do so. Our analysis, we found that there was enough space to get enough parking to get the trash enclosure located on site and allow a 5-foot setback along 9th. We do concur that there is not enough space along Creston to allow for all this to take place and provide a 5-foot setback up there. There isn't a better spot on the site either for the trash enclosure, so we concur with there being a hardship or a challenge in locating that. I think that was kind of my rambling version of the staff recommendation. So once again, we are recommending approval of the variance from Creston, the variance for the trash enclosure, and then denial of the variance for along 9th Street. Happy to answer any questions.
Jason, is this drawing you have in front of us here, did the city kind of put this together then?
Yeah,
as a
we did this
sketch?
as staff to show that it was feasible to meet all the dimensions.
Okay, but what you're also showing here then on Creston, where you've got it hatched in, you're showing converting that to green space, correct?
Correct. There would be a sidewalk through here. That's a
Yeah,
mistake
okay.
in the drawing. There would be the sidewalk,
Okay.
but this does show that the applicant restoring the right-of-way. You saw from the picture that right now it's, the zoning doesn't cover paving into the right-of-way, but
Okay.
so the variances are written up from their property line, which, you generally assume kind of back here.
Mhm.
So you'd maintain your sidewalk in each direction.
Okay.
I guess we have most of it in place here, but
Right.
this would all need to be restored.
So going back to the drawing you had, what options, or what are you willing to concede from anything you've drawn on here? Or this is pretty much what the city wants to
This
see?
is the staff recommendation. We think
Okay.
this is a reasonable
All right.
alternative.
So along Creston there, you'd want the green space restored. You'd
Correct.
want that apron taken out.
I think that's a fair trade-off from not being able to provide that 5-foot setback. They certainly have challenges there, but we do strive to get people to work towards meeting our standards.
Okay, but are you showing the 5-foot setback here then?
No.
No, you're not.
No, this is the property line.
Okay. Got it. Okay. All right, I'm with you.
Can you show us the aerial that you started with again?
That's helpful, what you pointed out. Thanks.
You also notice how close this drive approach is to the intersection.
Mhm.
And there really isn't an opportunity because of that grade. That picture I showed earlier that showed that Creston slopes down from the site, so there really isn't a reasonable alternative as far as a drive approach off of Creston further to the east.
So I'm confused. Do they have to do a sidewalk running east-west on Creston?
They would need to retain a sidewalk, yeah.
The
Right
full,
now,
the
they
sidewalk to
have
nowhere?
pavement, sidewalk pavement, and then,
Is there a sidewalk to the next property on Creston
no.
at all?
no.
Then it's a sidewalk to nowhere you're requiring?
What we're if the concrete's already there, we're suggesting that
Hmm.
if they're gonna tear it out, they just tear out what they need to, not tear out more than they have to.
Well, and they don't want to tear out any.
Correct.
Right.
Well, question, so you want them to put a sidewalk there, so you want them to tear up the grass that's there too?
No, we're just talking about, we're just narrowing down what they need to do with regard to
Right.
how much concrete that has to come out.
If they removed all of it, I don't think we're going to have a problem.
Right.
Sure.
We're saying if you leave the 4 feet for the sidewalk there, and that reduces the amount of concrete that you're removing. Does that
Well,
make
the-
sense?
The sidewalk's on city property, isn't it?
Correct. All this is in the right of way.
Why would they be liable to put in a sidewalk on city property?
Everybody is.
That's that, what I'm saying is that instead of requiring them to take all of the concrete out.
He doesn't understand.
I understand that, but why would they be liable to put a sidewalk on city property?
Well, anytime you would do redevelopment of a site and there's not a sidewalk, that would be something that would be a standard, but.
So they'd have to tear it all out and re-pour the sidewalk?
No, that's not what I'm
They'd leave
suggesting.
it 4 feet.
If they can create a sidewalk out of what's there, if there is a sidewalk that's in between the pavement, then leave it. Why, I guess my question is why create more work for them?
Yeah, we kind of see what you're doing, but you kind of leave a apron that could be used as a sidewalk. It's a sidewalk to nowhere, kind of like the bridge to nowhere.
Sure.
And there is a sidewalk on the other side of Creston, and, but, yeah.
We do require sidewalks to nowhere on occasion.
Yeah, I know, I saw it in my neighborhood.
Because incrementally, then we get to that point
But-
through site planning, so.
But this is a sidewalk, a half a sidewalk to nowhere.
Right.
Yeah, no,
And you have a complete sidewalk.
like I said, I don't think we would object to it,
Right.
them removing the entirety of it.
I see what
We're just
Jason-
suggesting they could leave the
Right.
portion that would.
I think to a
serve-
certain degree, it just seems like a little theater of, well, we're debating about a sidewalk that
Yeah, I think we're
may or may not really be
caught
there.
up on a detail that wasn't really the heart of the staff recommendation.
Right.
saw cut it and take out what you need to. It's
Yep.
kind of the point of the staff rep.
I have another question. Why are you asking for the dumpster enclosure to be masonry walls?
For durability purposes, it's a standard that we've required.
I haven't ever seen that before.
It's a norm.
Yep.
I mean, it
Right
doesn't
down
mean
in
that
your
there aren't dumpsters around town that aren't that haven't been around for a while, but the past few years, that is a standard.
Well, I've never seen a requirement for masonry walls around a dumpster enclosure. Where's that coming from? Do you have a law or something? We've never had it in the 4 or 5 years
The
I've
zoning
been
ordinance
here.
has language in it, and I'll defer to Eric to recall the exact language, but it talks about the durable materials and
But you're asking for masonry. I've never seen that.
If you would prefer not to make that a condition and leave that up through the site plan review, then that's your decision, but that is something that
I
we
mean,
stand.
my question, I guess, is how expensive do you want? If I was the applicant, I'd walk away. I don't understand.
I guess, I don't have really, that's your decision to make. We've made a recommendation based on the best.
Well, I'd like to know
standards
where
and
the
practices.
masonry walls are coming from. I've never seen that
Okay,
request.
That's your right to have your position. I don't think that.
But you're still not answering my question.
No,
Where?
I've answered your question. You're just not accepting my response.
All right.
If I can address that.
Go ahead.
Maybe I shouldn't even try. We have required masonry walls. If you look at Gateway Market, for instance, those are masonry walls, and that was a site plan requirement. The reason for masonry walls is it is durability and it looks better. You could say masonry walls are alternative design as accepted by the planning department, and that would satisfy. It'll have to be something durable that doesn't fall apart when the garbage truck hits it.
I'm not questioning that. I'm questioning it says masonry walls. It doesn't say something durable. And I've sat on this committee for 4 years. This is the first time I've ever recall seeing it be masonry walls, period. Where is it coming from?
It's coming from the site plan requirements,
Uh,
Chapter 80.
Then have you, as the staff, not presented it properly on the other things I've sat on? I'm asking her.
I believe that has been made on other cases when it has come forward to you.
Well, but I don't understand why a business person would, if I was a business guy, I'd walk away. I mean, I think this is just ridiculous. I don't see how anybody could possibly afford it.
Yes, and the city has indicated that they would entertain the notion that it be constructed of durable materials or masonry walls. Does the city have any additional comments?
It says other durable materials. That doesn't.
Approved by the planning director. We're saying let's restrict.
Why isn't that in your recommendation?
Because we wanted masonry walls. We wanted durable materials. That would reduce the flexibility of this provision in the code that's already in the code. And it is a requirement. We've been requiring it for about 3 years now.
So if they come back and say we can use X durable materials, that's not good enough for the staff?
In this case, we believe that they're asking for something that waives our ordinance. And in trade-off, we want to get more quality material.
So the answer is no.
The answer is we want to restrict it further than this by having that provision. If you want, they can still be within the code if you don't require that. We are still going to require something in terms of.
I'm not questioning that.
But it is a standard, so I mean, I didn't want you to get the impression that we have.
No, it's not a standard. I disagree totally. It says brick, masonry, or other durable materials.
But that would have to be approved by a special review of the planning director.
Approved by the planning director.
In this case, we're just saying, because they're asking for some variances, we want something in return, which is the durable material on their enclosure.
You want something in return over and above tearing out how many linear feet of concrete and putting it in sod?
Yes.
I think it's ridiculous.
Does the city have anything else?
No.
All right. Applicant or representative of the applicant?
Terry Konchowski, 729 Bell Avenue. You know, speaking with Jose, we have no issues with what they're requiring. The sidewalk doesn't make sense to leave it. There's a hill that goes like this.
Yeah.
Tear it out, we'll put sod in.
All right.
It's not a big deal.
Okay. So you've seen the staff recommendation, and you don't have any objection to it?
If that's what they want, we'll put it in.
Okay. Anything else?
Mr. Chair, just real quick, Terry, are you the property owner?
No, I'm not.
You're not the property owner, okay. Who is the property owner? Okay, and the property owner is okay with all this too then? Okay, all right. I'm glad to see that. This corridor needs some help and needs some reinvestment, so glad to see that.
That's what he's trying to do.
Right, and the sidewalk thing, yeah, it sounds a little silly, but I kind of think you get it.
Thank you. Is there anybody else to speak in support of item 14? Is there anybody to speak against item 14? All right. We'll close the public hearing and go to board deliberation.
I would move all staff recommendations. And that's 2 parts there, so.
Right.
Well, the staff recommendation is in 4 parts, 4 paragraphs.
Yeah, you got to flip the page, yeah.
Right,
Right. All right.
right, yeah.
So you're moving staff recommendation.
Staff recommendation.
All right.
I didn't know if we needed to do denial for the 5 feet less, but I'm in favor of everything that the staff recommends.
All right.
And I think the appellant stated that they were okay with that as well. Based on that, I would strongly second that from a positive standpoint.
Item 14 has been moved and seconded to approve it, subject to staff recommendations. All those in favor signify by saying aye.
Aye.
All those opposed? Okay. Item passes 5-1. Okay, item 15. Barbara Bagley at 2000 Easton Boulevard. Exception and variances.
Materials. As in the staff report, this request is coming to you following the expiration of a previous variance, which allowed the property to temporarily be used without any setback required setback from Easton Boulevard and East 22nd Street. I'm going to give you, the photos will probably show this a little better. This is looking at the site, which is now not in use. Since the time of the variance expiring that was previously granted, 6 months have lapsed, and therefore they have to conform to provisions by setback in residential district that it falls within. So that's why the difference between the 30 feet and the 5 feet that it was previously granted under. It doesn't really matter. There's still the notice was basically for all of the setback to continue to be allowed to be paved. A letter that was part of the application indicates otherwise, and I'll let the appellant kind of go into more detail on what they may be willing to do in between where we're recommending and what's being noticed here. But basically, the way it's noticed wouldn't actually allow the current condition because some of that paving actually goes into the right-of-way. This is looking to the north. I'm sorry, that's looking to the south along East 22nd Street, kind of south and a little bit east, I think. Easton comes up this way at a diagonal. So this is East 22nd Street is to your right. Easton is in the background there. So you'll see there's basically a 0 lot line condition here to the sidewalk with the paving. This is the area that they want to expand display into that's currently not paved. And so that also requires a variance to allow expansion of a use that's not permitted in the residential district. Now if we look down Easton to the northeast, Some of this area had been restored even previous to the board variance before. Other parts of it are further to the northeast, or zero lot line, or actually paved into the right-of-way based on where the property line sits. And this is a little bit more zoomed in so you can see. There's actually parts of the right-of-way that are beyond the sidewalk here, so the lot line actually kind of follows an area. Now, at the time that the previous relief was granted, that was a condition to restore those areas. Well, nothing was really done physically to the site from the time the previous variances were granted. The way staff has kind of looked at this is we have a commercially developed site. It would be very expensive, I think, to remove the improvements in its entirety and convert to a residential use, which the zoning would permit. So from that standpoint, we believe there's a hardship in not allowing the use as a whole to continue. From that, but secondarily, we do believe they can still comply basically with the provisions they were granted previously on a temporary basis, which was to provide a 5-foot setback in this area and along the 22nd Street side as well, and still be able to maintain their operation. Any expansion, we believe this site would be overbuilt and overdeveloped to allow expansion of the display. So we do not favor that variance. So if you look at our staff report, then we would recommend denying the variance to allow the expansion on the site that's being proposed.
Eric, where is the expansion? Is it behind the building?
Map. I'm sorry, I should have shown you the sketch.
I can't figure it out.
If you're looking at the buildings, the two buildings, this is the area out front along Easton, and then that photo was looking to the south, along Southeast 22nd. The fenced area was right up in here.
And where's Easton? I'm sorry.
Easton is this street right here. This is Southeast 22nd.
But along 22nd, that's all residential back in there.
Well, there's a church to the west.
Across the street.
Yeah.
But on that same street.
So if you look,
back.
kind of the depth of the property is not as deep as where the church is to the west, and there's another parcel which doesn't have a dwelling on it to the north. So if you look at this photo here, you can see there's some space between here, but we think this is serving as an adequate buffer for right now, based on how it's been used in its history. To allow the display to kind of occur in here, I think would be a impact to the essential character, and that's why we would not recommend expanding into that area.
Are these the same applicants that go back to?
My understanding is this is the successor, the spouse of the deceased, who was granted the previous relief. So
that's the spouse?
Yes. She is looking to allow this to be, get rent from this for a commercial purpose.
And that deceased spouse was the one that
Right, you were negotiating with him at the time. And asked him to remove anything in the right-of-way and temporarily allowed him to have a zero.
And that was the one that had the 2 years to do it?
Right.
Okay, all right.
And then that's lapsed, and at the time it lapsed, then the clock started ticking as to non-conforming provisions. And so now it needs to meet residential zoning, essentially. So we're in favor of the continuation of the non-conforming use of the land as a whole. We believe it can meet the variance test on that provision. We do believe that they can conform to the things that were to be met after the end of the temporary previously. We also do not support then the expansion of this site into an area that did not have displayed over.
Could I ask you to put the picture up again? I'm sorry.
Which one did you want to see?
Of the buildings?
The buildings. So looking at it from kind of the...
Yeah, and so these buildings are separate, they're not connected?
No, there's a little gap, but I don't think there's much ability to...
So if I'm getting...
Or maneuver between them or...
So if I'm getting this right, this display area wouldn't even be on the busy street, Easton, it would be on the...
No, it would be towards the neighborhood, and that's why we would believe that it's.
That's what I'm getting at.
Yeah. This is kind of looking down the back property line to the
Yeah.
east. So there's this vacant land that's in between. However, if they display right here, then you're pushing that display activity closer to the residential neighborhood, and we don't think that's appropriate. So we're recommending denial of that provision that would expand the use. But we do recommend approval of an amended variance to allow them to go within within 5 feet of the right-of-way lines on Easton and on East 22nd. And then we also state that they would have to do this by November 1st, or everything is lost, and then they have to go back and seek rezoning.
What is it they're going to display?
Used vehicles. And so if they expand, they would also be subject then to going to the Plan and Zoning Commission for a site plan that would meet our vehicle display lot design guidelines, which they'd have a number of waivers to make that work as well.
Was there any discussion with the applicant about maybe just tearing down one of the buildings to have more display? Or was
No, I don't think that entered into it. There is some proposal to do a portion of the landscape setback, not the entire 5 feet that we're recommending.
I just wonder if it's worse to display cars there as opposed to razor wire. I'd rather have a car parked there.
Valid question. The razor wire will lose its non-conforming rights as well at some point. That was not part of the appeal, so.
So it's coming down one way or the other?
The wire.
The wire.
If this gets back into use by November 1st and meets any conditions that you would put on them, then I think that they would actually still have the non-conforming rights on that. There's certain things that are 6 months, there's certain things that are a year, and use of the land is 6 months, structures are looked at differently.
Eric, on the right-hand side of this image that we have in front of us, is that a 20-foot dimension between the building and are you sitting clear to the right?
Over here? Yeah,
Yep.
That's the narrow point.
So am I reading this, that you're getting your 5-foot setback that way?
They would be able to get a 5-foot setback, and that would still allow passage of a 1-lane to get to that egress on the east. I don't know if there's a better view of that to sort of give you that. So there would, if you took the 5 feet up here, there would still be a threshold that they could circulate between where that constraint is on the building. Now, if we started fresh, there'd be a number of standards that would not be met here, of course, from a site plan perspective.
Okay, are there any further questions for the city? All right, applicant or representative of the applicant?
I'll just leave these up here in case you need to look back at them.
All right.
In fact, I'll stand here and put them up there if you need to see them.
Can I pass these out to the board?
Yeah.
Yeah. My name is Ron Bagley, 235 Northeast Plum Avenue in Earlham, Iowa. Got a short letter I'd like to read to the board. My father owned property at 2200 Easton Boulevard since May 1st, 1974. This location has been used as a car lot the entire time after retirement. My father leased the car lot. It had the same tenant for the past 5 years. In the past year, my father became sick and died February of this year. On May 1st, the tenant turned in his notice to move from the lot. Shortly after, we were contacted by a car lot, Hope Auto Sales, to rent the property as an extension lot. She was approved by the DOT as an extension lot, and when we went to the city for their approval, we learned that the matter of the matter that my father was before the board in September of 2009. We learned at that time my father was given an order for a landscape setback of 5 foot with 2 years to comply. The 2 years was up in September 2011, and nothing has been done to comply to this date. We need to get this matter resolved so that we may rent the property. We understand and want to comply and have prepared site plans with a 0 setback, 2'6" setback, and a 5 foot setback, and have figured out the amount of cars the lot can hold with each of the setbacks. The figures are on the bottom right-hand corner of each site plan. 0 setback can hold 32 cars. 2'6", we'd be able to put 20 cars on there, and with a 5 foot setback, we'd only be able to display 13 cars. And also asking for parking to be added at the northwest corner of the lot to make up for the lost display on the setback. We would be happy to do any landscaping necessary if granted. Only one property touches ours and is owned by Sunshine Open Bible Church, which I've enclosed a letter from them regarding their thoughts.
Sir, in your letter, you say that it's been a car lot since May 1st of '74. I remember it being a car repair shop, but I don't remember a car lot.
There may have been, my dad opened the car business in 1974. I actually worked for him. There may have been a short lapse between this leasee, the last leasee guy, and Dad, where there was some type of a repair shop or something in there.
It was there for quite a while. I don't remember, maybe Eric can tell us if there was a vehicle display lot.
I don't know the history on the licensing for the, you know, there's a number of lots that may have had 4 or 5 cars with an auto repair or something. You know, those are hard to track actually.
Or their cars could have just been sitting there waiting for repair and it looks like they're for sale, even if they're not, just because they're parked waiting.
He just says it was used as a car lot.
Okay.
And again, we didn't always look at licensing it and use. I mean, if they had 5 or fewer cars, it might have been seen as accessory to repair, or you know, and they still needed a state license. We're definitely more attuned to the use and whether they're licensed through the state and whether they comply with our site plan requirements, so, which has been in place basically since 2002.
Ron, would you be directly operating the business?
No, we'd be leasing it.
Okay. And you'd be leasing it to someone who's just going to do auto sales there?
Yes, that's the plan.
Okay, they wouldn't do just general mechanics, like pull in and do a brake job? Okay.
No.
So you'd use the shop and the 3 bays there to just prep cars
their cars,
and do your own repair for the cars you're going to, or that they'll sell? Okay.
Yeah. The whole thing with a small lot like that, I mean, obviously you need to display as many cars as you can, and if you're only able to display 13 cars or so, I mean, it's just going to be hard to make a business like that work, you know?
So you see what the city's put on the table as a staff recommendation. I know that doesn't maximize your cars, but from your perspective, does that knock you down to these, 13 cars? If you have to do the 5 foot setback?
Yeah, for 5 foot setback.
Okay.
And that's why we'd like to make get an exception for a 2.5 foot setback. You know, and do whatever's necessary in the landscaping or bushes or whatever, you know. Neither I nor his wife knew any of all this, and, you know, I know on the east side of the car lot, out toward Easton, I know it's a paved, clear sidewalk, and, you know, it's just something they did back in the day, and we had no idea that it was like that. I mean, we're more willing to take it out and do whatever we got to do that way, you know?
Any other questions of the applicant? Thank you. Is there anybody here to speak on behalf of the applicant? Is there anyone here to speak in opposition to the applicant? Okay, we'll close the public hearing and go to board deliberation.
Well, again, I like the staff recommendations. That's a new you know, they've just opened that area up there to get onto the freeway. And we've got a lot of traffic going on there, and I think we need the landscaping, and we need to make that look better than what it is. So I would have to go along with staff recommendations. I don't see any reason not to. I don't like having that space back there that's all residential. I go up and down that street quite a bit, and I would not, I like staff recommendations.
Eric, was there any consideration in the give and take discussion with the applicant about?
I think we kind of looked at it as we're okay with them living up to the promise that we thought was going to be met as of October 31st last fall. And at that point, he would have been able to continue under the previous variance and would have been in good standing. And
Right.
I think we looked at it, what has really changed, that we would impose a lesser standard right now. And we couldn't come up with anything that really had changed. Possibly the economic environment has changed, but we don't normally throw that into the mix unless it's extreme, you know.
The rest of my question was, we discussed a little bit to the north of the west building, the razor wire. It seems to me that there could be an improvement made to that, at the same time granting the applicant some relief and additional car parking along that, in that fenced-in area, if the fence were removed and a landscaping buffer were applied to the northern border of the site.
And you would be able to do that under the way it was noticed and require that as a condition. Now, what I should tell you is if you make that recommendation by it being an expansion, then that will cause it to go in front of the site planning review process, and there would be the possibility that it could be denied under those provisions.
I'm not trying to make it worse for him.
Yeah.
Okay.
I'm just pointing that out so that you know the board can grant that, but there's still a possibility of not getting a site plan approved on that.
Would it be an expansion, Eric, if in fact the property as it now is configured can hold 32 cars, but then my understanding is that if we allow the expansion into the grassy area, that allows for an additional 5 cars. And so if we give him his 2.5 feet and the additional 5 cars in the parking area, that's only 25 cars.
I think you can rationalize it that way.
It's not really an expansion of the...
It's not an expansion of the number of cars being displayed, but the way the code reads, it's an extension onto property that's not previously for that use.
Okay, so they
if you
count
want to
the square
rationalize
footage of the property, not the number of cars.
Right, and it's based on land, what it was previously used for, whether that use is being extended to a portion of the land that was not previously for that use. So that's why it's considered a variance in this case. But if you want to, as a board, kind of weigh those, kind of look at the scales of what's happening in terms of number of display, that's up to the board.
But it still would send it to...
Yeah, by extending it into that area, it still would kick in our site plan provisions.
And his condition might be worse than anything that we would grant him.
Yeah.
Well, he still might be denied the use of that expansion. I mean, he still may be denied a site plan that would allow that expansion or
Could he
extension.
sell lawnmowers on the grassy area?
While he's mowing.
You know, I don't know if there's anything about this that would restrict what the, you know, whether it's boats or, you know, we didn't really limit it from that standpoint. It has traditionally been used automobiles, but the way the ordinance sets up the use, it's farm implement, motorized vehicles, equipment for rental, sale, hire, so like an ATV or, you know, it could be a number of things, but anything that would basically require a license through the state, I think would fall under that.
So I'm just going to suggest another one with the now clear rules to me. Why don't we suggest that in exchange for the smaller setback than staff recommendations, we ask for some commensurate landscaping in that area and the fence that...
I think those are all things the board would have the the leeway to negotiate.
Eric, to expand on what Jake just mentioned, if they just had the 5-foot setback, like staff is recommending, would they just have grass in there and mow it? Would they have to landscape it with plantings aside from the grass?
Because they're not going through a site planning process, it's not triggering those actual requirements, so.
Okay.
I would say no at this time. That doesn't mean it wouldn't be a desirable thing.
Okay. All right. I'd be inclined to find a way. We had a case like this on Army Post Road. I think it was Ananias, where a car lot building burned down. The 5-foot setback was going to push the cars where they'd hit the building, so we did like a 3-foot, but we really said landscape it nicely, don't just put in grass. So if we gave a little more on that 5, like what Jake is referencing, I'd like to see, maybe spirea bushes or something. You can't have an overstory tree in a 2.5, 3-foot stretch, but have something besides grass.
When this was reviewed nearly 3 years
have
ago,
more
I
than the grass.
think the real thing that was important was that the vehicles were encroaching over onto the sidewalk, and it was a problem for pedestrians moving along either street corridor.
Right.
And so by providing that setback, we were getting those vehicles to pull back from being across the sidewalk and encroaching into the right-of-way. Whether 2.5 feet does that, I think I'll leave that up to the board to decide whether that's reasonable.
Well.
Any other comments from the board? Let me make a comment. I think that if we follow the staff recommendation, and if, in fact, what the applicant has given to us is true, you reduce it to only 13 cars, that seems, just commercially unreasonable. I can understand that, that it's a standby lot for somebody that's already in the business and that kind of thing, but I think that the idea that we compromise on the 2.5 foot setback would make a lot more commercial sense.
But still not.
Not allow parking and that kind of thing.
I just don't like that part. Well, I don't like this here on the 22nd Street.
Right.
So no expansion.
So no expansion. I think that once the applicant understands that if we expand the use, he goes to site plan review, and that's even worse.
Right.
We don't want to send them to the...
He doesn't want to do that, no.
Can we request that barbed wire come down, though?
Yeah.
And do some landscaping there?
We're making a deal?
In exchange for the 2.5 foot?
What you think, Mr. Chairman?
Well, I think you can propose anything you want.
Okay.
I'm not here to tell people what to do. I'm here to chair a meeting.
What a nice MC.
Going along with the second part, except we want to change that to provision of a 2.5 foot landscaped perimeter. Correct?
Yeah, recommends approval of an amended ordinance 25 foot less than the, so
it'd be 27
and a half feet less than the required 30-foot yard setback.
And remove the barbed wire and landscape.
And when we say landscape, we mean grass and some ornamental plantings.
Make it look nice for the neighborhood.
Is there a way we can kind of...
I think if you want to look at a standard that, that's probably no more than a 50-foot lineal section of, we would normally require 1 overstory and 3 shrubs.
Okay.
So again, it can be
or an
whatever
equivalent.
you say.
Yeah.
Or if they wanted to do 2 ornamentals instead of 1 overstory.
Okay.
But yeah, let's not do a requirement for overstory because birds are hard on.
Right. Yeah, I'd rather just see some nice spireas, low, cover it, look nice, but some equivalent landscaping.
Approved by whatever the city, whatever they in the city can work out.
Right.
And I think we would look at it in terms of the landscape perimeter provision.
Okay.
Make that motion.
Well, you had it.
I'd like to ask the applicant if it makes sense for him.
Yeah.
Does what we're discussing make sense to the applicant?
It's not right. It's not the best, but it's compromise.
It's just what we rock or sod or bushes.
If you will, would you come up and speak at the microphone, because they cannot get a recording of what you're saying?
That's fine. I guess that's the whole thing on the setback, is just what materials we'd be using in there, whether we could put rock and some bushes, and obviously we don't want trees for birds' sakes and the cars and all that.
My
but-
understanding is you're saying the landscaping in that open, the already grassed area that's there on the site? I don't think they were suggesting anything. Were you talking about anything along Easton or?
Well, where he'll be cutting out, if he's cutting anything out
Yeah.
and replacing it,
If it was down to 2.5, I would say no tree.
right, just grass and some ornamental shrubs that make for an equivalent amount of landscaping.
So we wouldn't want to see any trees within a 2.5.
No.
And
I mean, they wouldn't
there
be
is
blocking
razor wire there on that one area, and removal of the razor wire.
Would that cause you any grief if you had took the razor wire off the fence?
None.
Okay.
And then where would we stand with the actual extension of the lot? No, or just because zoning and all that?
Yeah, we wouldn't give you an extension of the lot, basically because it would trigger a site plan ordinance review.
I got you.
At
It
which
goes beyond
point,
us, right. We're trying to give you the best, I think, at least with a few of the
Oh, we
comments here,
appreciate
the best
that.
we can, but still keeping things looking good and improving the corridor as a whole.
Yeah, I mean, we'll do anything as far as plant, like I said, trees, shrubs, whatever.
Okay.
Yeah, I don't know if you can let us get on the right of way at all, or not with bushes or anything, but
we just don't have that authority.
yeah, we'll do whatever we need to.
Okay.
Okay. Could I hear a motion from one of the other of you?
I'll make the motion then to deny the requested variance to allow expansion of a non-conforming vehicle display lot, everything in paragraph 1, and then to allow approval of an amended variance of 25 feet less than the minimum.
27.
20, or we were going to make it 27 and a half feet less than the minimum required 30-foot front yard setback from adjoining street property lines, subject to removal of all paving encroaching into the public right-of-way, and provision of a 2.5-foot landscaped perimeter adjoining Easton Boulevard and East 22nd Street. And everything has to be done by November 1st of 2012, or all other non-conforming rights will be lost. In addition, the applicant has to remove the razor wire that is behind from Easton and East 22nd, and that is to be landscaped along with the front along Easton is to be landscaped with acceptable designs by the city of Des Moines.
Do I hear a second?
I'll second that.
It's been moved and seconded to modify the staff recommendation in accordance. All those in favor signify by saying aye. Aye. All opposed, motion passes 6-0. Did you get all that written down, Mike? All right. Item 16 has been continued to the next regularly scheduled meeting. Item 17, the Des Moines Waterworks for a special permit and variance at 903 East Pleasant View Drive.
Yes, Mr. Chair. Not long ago, you looked at a fence for this same site. I believe it's the Winchensky standpipe? Okay. They named all of their standpipes after former directors or boards of director members of the Des Moines Waterworks. So some 3 or 4 names that run around town here. This is the property. It's just west of a land lease community at Indianola and East Park, Indianola Avenue and East Park. So you can see this property here. The primary access is coming off of East Pleasant View Drive from the north, and it wraps around. And there's communications tower equipment within that area and some other control equipment that is used by the waterworks and by emergency services. And the purpose of this request is to come up with a modified equipment, development of equipment to service those needs And I think it includes an expansion of those needs. So if you come in here, and right now this is a white rock drive, and that's not a preference for us. We want to see a dustless material for that drive, but they are also extending the area here for the, for some turnaround and for parking, temporary parking, to use this new equipment building. The equipment building does meet all the setback requirements. I'll defer to them, but I believe this building will replace what's up here, but it may be in addition to, so I'll let them qualify that. I think these are going away, but I could be wrong. The big thing here is that we do want to make sure this is paved with a durable material.
Just a turnaround.
Yeah, just this area that's hatched. And in future maintenance of the driveway itself should use a dustless material over time versus keep continuing to replace the white rock itself. So we're recommending in favor, subject to the substantial conformance with this sketch here, and then that it all codes are met, and then we do recommend denial then of the provision which would allow this not to be paved. We do want to make sure this new extended area is paved.
Do you want it paved, or do you want it to be a dustless surface?
Well, that's something the board, I think, can consider as an alternative. Right now, we're saying paved. I think ideally, we would have liked to seen all of it paved.
Okay.
But I don't think we can really speak to some of the existing, but anything they're extending, I think we have the ability to say that should be paved. If dustless material is acceptable, again, I would also say that the driveway, as it's maintained over time, should probably be maintained with a dustless material versus a white rock material. Are there any questions? I do have photos if you want to see site photos. I'm just trying to get back on track here if we can, time-wise, so I can pass those around too if you want to take a look at those.
Is that stated denial of the requested variance of the provision that requires the proposed access turnaround?
Eric, just real quickly, you don't necessarily talk in your staff recommendation about if they make any future repairs or resurfacing of the existing gravel,
Right.
what you want.
I'm saying
but-
that, it's not something.
But if that was potentially a condition that we
But I
decided
was
to
saying, if
throw
we were
in.
going to negotiate a different material,
Okay.
then I would say let's apply it to the entire
Yep, okay.
set of surfaces.
I get you.
Yeah,
Eric, I want you to look at your staff recommendation on page 42.
okay.
There's an agreement among the attorneys here that the last paragraph doesn't make any sense. That's not what you want to say.
We're saying a durable surface, which would be paving as well.
Not dustless, you're saying durable.
Right.
That's
You're
different.
recommending denial of a variance
That would waive the paving.
that would waive the ordinary paving
Right.
requirement.
Right, and so if you look at that second to last sentence, we don't believe that it meets the criteria.
Right.
And then we would say it is appropriate to have a durable surface, which would be the paving. If you want to read something lesser into that, that's up to the board.
We want it to be paved.
That's what we're really trying to say there. It should have said paved, probably, instead of durable.
Well, this says staff recommends denial of the requested variance of the provision that requires the proposed access drive turnaround to be paved.
Right, so they've requested to not pave it. We're saying it should be paved.
He probably should have said the word paved up above in rationale instead of durable, to be
Right,
consistent.
that's what I said it probably should have said paved instead instead of durable. The follow-up sentence was there to say, to justify why we didn't want to recommend granting of the variance. We're trying to rationalize that this new expanded area should be of a durable surface, and if you want to take that to something less than paving, then that would be within what was notified.
Is this picture here the approach off of East Pleasant View then?
Yes.
This is the apron approach off the curbing?
Yep.
Okay.
It's kind of a wide right-of-way there,
Sure.
so it's actually more like a,
Okay.
the driveway extends
Yep.
into the public right-of-way there.
Okay.
If you recall, they pulled their fence back 25 feet from the property line from where it used to be, so there's actually 25 feet of their land in front of that fence.
All right.
So what you were looking at was this,
Mm-hmm.
this segment right here.
And Eric, did we make any requirements before with the fence approval for them to make any improvements outside of that fence perimeter, like to approaches or drives or anything at that time, do you recall?
I don't believe so. I'll try to see if I can find the decision.
Yeah, because I thought we said that something about they wanted to keep the fence or set it somewhere, and we said, well, if you'll do a little of this on the outside of the fencing. I might be stretching the discussion there.
They already have large
some overstories there. Okay.
trees, and so I'm not sure.
All right, I'm just curious. If it doesn't ring a bell,
Yeah, I'm not
it's
sure
no big
what we
deal.
would
Okay.
impose, to be honest with you.
Yep.
Whether we would have said to pave that approach, I don't know.
Right. Okay.
Any additional questions of staff?
No. Thank you, Mr. Chair.
Thank you. Applicant or representative of the applicant?
Members of the board, my name is Marty Dostalik. I'm with Civil Engineering Consultants, 2400 86th Street, number 12, Urbandale. We represent the Mediacom, the applicant. This facility is going to be combined use between Mediacom, Des Moines Waterworks, and the City of Des Moines Emergency 911 Service. It's going to be a communication hub building for some antenna that go on top of the water tower there. The access to the site, it will be very limited, approximately probably one vehicle per week coming in on the drive. We see no need to upgrade the surface of the entire driveway. Upon speaking with one of the city staff members, they recommended in lieu of adding gravel onto the site for a turnaround, we use like a recycled asphalt product so that it is a dustless surface. For one vehicle a week, we see no reason really to pave the entire drive or the turnaround into the site. Really serves no purpose for that low of a volume. I'll be happy to answer any other questions you may have.
Yeah, I have one. Do you then agree that you would use recycled asphalt or some such product like that to provide a dustless surface for the parking area?
For the area that we're adding on, yes.
Yes, okay.
And Marty, would you be able to make a provision that if you were granted the dustless surface, maybe with a little deal making here, would you keep that free of any encroachment of weeds into the material?
That would be a maintenance issue for the waterworks and Mediacom, I guess, to take care of.
Doesn't that black fabric spread down still stop the stuff from
Do you have some in your landscaping? Yeah. No, good roundup.
Grow in rock.
Yeah, good old roundup. Yeah.
All right. Any other questions of the applicant? Thank you. Is there anybody else to speak on behalf of the application? Yes, sir.
Kyle Danley, Des Moines Waterworks, 2201 George Flagg Parkway. Des Moines Waterworks staff is in favor of this project. One of the existing buildings that they spoke of is deteriorating and needs to be replaced. When Mediacom contacted us, we thought this was an opportunity to combine two buildings into one that would be more attractive to the neighborhood than having multiple other buildings. And so we asked them if this would be a possibility to combine one of our buildings on the property with their building and then demolish the other building in process. So we are supportive of this project and would like to move forward with it if possible.
Just a quick
Go
question.
ahead.
Will you be taking down both of those buildings, or can you point out which building will come down?
This building currently is the one that we own that houses our equipment and the city of Des Moines equipment. This other building that is very similar to it is actually, I believe, owned by another utility, but is leased on our property. And so that would stay at this point.
Any other questions? Go ahead.
I just got one I'd like to throw out. Kyle, if we were inclined to look at allowing you to, do your parking and turnaround with something dustless, like maybe some cinder material or something, I know that'd be a lot of area to pave, and I know that's what the city would like to see. But I don't see too many people that see the interior of your site, and I'm sure you'd take care of it well. But in your picture here, this is your approach to the site off the street, and you see the gravel's out here off the curb and out into the street. What if it's kind of a deal you could just pave the apron up to the fence, keep the gravel drive, put in your dustless surface, a little quid pro quo for everybody?
That area there would be probably half of what the parking lot's going to be.
Mm-hmm. Yeah, see, so it's half the amount of paving. I mean, really, I think a lot of what we get to with gravel is stuff like this. We've got kind of an undefined approach here. I mean, the gravel doesn't really even get up to the fence. It just doesn't look very good in the middle of that's a nice looking street. Your facility is a nice looking facility.
Sure.
But it'd just be nice to somehow get that improved one of these days.
The details of the cost sharing of the project have not been worked out with MediaCom, so
Okay.
I guess that would be something we'd have to discuss to
Okay.
see if they would be willing to participate in that.
Okay.
That's something we can
All right.
discuss.
Okay. All righty.
All right. Any other questions? All right. Okay, thank you. Is there anybody here else to speak in support of the project? Is there anybody here to speak against the application? All right. We'll close the public hearing and go to staff deliberation, or to board deliberations.
I would move staff recommendations.
Well,
A second.
staff recommendation is requiring them to pave the turnaround then, right?
They're doing ask for the denial to request them to pave it.
Oh, we went
Yeah.
through that.
It's denying the variance. It's denying
Right.
the requested
Yeah, so they'd
variance.
have to
That's
pay.
correct.
Okay.
Okay. Yes. I'll second that motion.
See, and I just offered him a chance.
Did you just second it?
No.
Right.
No, I haven't seconded it, but.
It's been moved and seconded that staff recommendation be approved. I would think that the last sentence there might be, staff recommends the denial of the requested variance to the provision that requires proposed access drive turnaround to be paved. Better English.
It's going to be paved.
Well,
You're saying the turnaround would have to be paved? The recycled asphalt would not be allowed?
it appears there's a motion and a second on the table for just that.
Well,
Correct, Mr. Chair?
that's correct. That's what I understand. Now, is there anybody that wants to propose any amendments to that before we vote on that? Okay. All those in favor signify by saying aye. All those opposed? Motion passes
Made a deal.
5-1. Okay, let's do one more before, and then we'll take a quick break. Item 18, First Christian Church, 2500 University, for a special permit and variance. I hope this doesn't take.
I should have made a deal.
Chair, members of the board, this is the Drake Neighborhood Farmers Market. There's the response map. I have cards that we can pass around. You've seen this before. They've been before you 97, 2002, and 2007 to get a 5-year special permit to allow this activity. Each of those times it's been approved. We're recommending approval again, denial of the request to allow it continuously or to have no time frame to it. Just a couple of quick pictures of the site. This is the parking lot behind the church that's used for it. It's located, here's the Drake campus, University Avenue, 25th Street. So we are recommending approval subject to the same conditions for the permit and then denial of the variance. And I'll go ahead and read the conditions. The farmers market shall only operate from June 1st through September 30th on Wednesday between 4 p.m. and 7 p.m. Signage on the site of the farmers market is only displayed during the times of operation and kept in good condition, and that the permit shall expire on June 27th, 2017. We believe that that's a good practice to bring it back every 5 years or so and make sure that it's continuing to operate in a manner that allows it to meet our criteria. Happy to answer any questions.
Is there any questions of staff?
Briefly. Jason, what's it cost for them to have their 5-year permit? Any idea?
We charge them the special permit.
They get $300 plus notification.
So $350.
Okay, all right, so it's about $70 a year if you divide it out. Okay, thank you.
Applicant or representative of the applicant? Go ahead. You're next.
I have nothing to volunteer.
I need your
Virginia
name.
Giske.
I need your name and address.
Thank you, excuse me. Virginia Giske, 1030 59th Street in Des Moines. I'm a member of the church, and I did start the market in 1997, but I'm retired from the market. But I'm here because the person that would have been was not able to make it today. I have nothing to volunteer. I'm happy with the response. We'd love to not have to reapply every 5 years, but we're okay. We can do that. Do you have any questions for me?
Just a comment, if there is a very strong feeling on the part of the church that they ought not to be charged for these permits, it's a city council matter.
Okay.
You can unite all the people that have farmers market permits and go to the city council. Anybody else have any questions of the applicant? Yes.
Just a question, Virginia, based on one of the comment cards from someone that lives on 25th Street that was not in favor of this. They write that you have unfavorable music, noise, and violence. Now, that doesn't sound like a typical farmer's market to me.
No.
Where would somebody get that conclusion? Any idea?
Probably somebody whose favorite parking spot was blocked for a while. Okay. That's being trivial, but really, there's no violence there. Okay. There's no objectionable music. I mean, this is a church-sponsored event.
I mean, maybe they don't like country music. I don't know.
Well, I used to have a playlist of what I called happy songs.
Okay.
And
I mean, is this amplified stuff, or do you just have like fiddle players or acoustic guitar
we can't
people?
afford live music. No, it's all pre-recorded.
Okay.
And the volume is low enough that buyers and sellers can have conversations. People that are sitting at the dining tables can have conversations.
All right.
That music got too loud, I'd go over and ask the DJ, please turn it down.
So it's just some ambient background recorded
It is.
music.
The market, it's background music. It lends to the atmosphere. Whenever there's no music, it's just dead.
Okay. All right.
You should perhaps ask the School of Music at Drake to tell people they can volunteer to put their hat out on the ground and come over and play.
Yes, we could do that.
Thank you.
You bet. Anything else?
No.
All right.
Is there anybody here else to speak on behalf of the application? Is there anybody here to speak against the application? Okay, we'll close the public hearing and go to board deliberation.
Is this your ward?
Do I hear a motion?
Well, I think it's a good idea to check in on this once in a while. I'd probably say Not because of the comment, but I think it's okay to review these every few years. I would move staff recommendation.
I will second that.
It's been moved and seconded to accept staff recommendation on item 18. All those in favor signify by saying aye. Aye. All those opposed? The motion passes 6-0. Okay, it's now 3:15. We have 4 items left. We're going to take a 10-minute break. We'll reconvene about 3:26 on the old clock there. Thank you.
Yes.
You know, next 2 weeks, this run around all the time.
We are now reconvening the Zoning Board of Adjustment meeting, and we are going to item 19, Iowa State Bank's request for variance and exceptions at 4100 Southwest 9th Street.
Here's the Chair, member of this board, Jason Van Essen with the planning staff. Before we get started, the cards going around, here's the response map, 3 cards in support. This is another case where we have a commercial property that was developed, has some non-conforming manners in the way it was developed. It's been vacant long enough, it's lost its legal non-conforming rights to those. So here's the subject property, Southwest 9th and Marion. An aerial showing the property. You can see that some of the parking actually extends under this adjoining property owner. They were signature to the application, so we're able to consider the request and allow this parking there because of the lease arrangement. You can see the pavement up to the property line condition. I'll just flip through these pictures, kind of give you a flavor for the site. There is some curbing. One of our recommendations is that there be curbing provided. If there is some in place that's in good condition, that could be incorporated into that. I know that I was trying to clarify that with the appellant, so you can see that some of that does exist. This is that perimeter where the parking extends, neighbor, backside. This is a sketch that we put together that supports the staff recommendation. It shows the drive aisle widths and where we're needing relief for that. So we have the variance of the 5 feet for the setbacks. The applicant's requesting to leave the pavement in place. 3 feet less than the minimum required, 20 foot for the 2-way drive area through here. Exception to 2 feet less than the minimum 12 feet for the maneuvering space required for the 45-degree angle parking, and then 4 feet less than the minimum 24 feet maneuvering space for the 90-degree. There certainly is some hardship in this area. We have a small site. It's an existing building. There really isn't a lot of opportunity. You can see that, their parking does extend onto the adjoining property. I will note that technically from a parking standpoint, if they were not able to maintain this, they could develop parallel stalls that would allow them to meet their minimum required off-street parking requirements. So this isn't a case where we're short on parking, it's just a matter of how the parking is arranged. Certainly we want them to have an efficient layout. We are recommending some conditions. You can see from the sketch that we see an opportunity to provide not fully that 5-foot setback, but kind of address it to the best ability. We show in this area in the corner here where there's no parking, that could be removed and easily converted to landscaping. As well, where the parking stalls actually end, your car, the front corner of it, the depth of that stall really ends here and comes across. There's an opportunity perhaps to entertain doing landscape triangles. I think in our staff recommendation we referred to doing sod. I think we're, that would be challenging here, more so important up in this area. So I think really the intent is, here, if the board wants to entertain this, doing something more like shrubs and kind of a landscaping rock or something like that would make more sense from a maintenance standpoint there. So I'll just go through the staff recommendation. Recommend approval subject to the following conditions: a triangle section of pavement In the front, angled parking area along southwest 9th shall be removed and replaced with sod. Excess pavement at the northeast corner of the property shall be removed and replaced with sod. And then the curbing that I mentioned, providing that around the perimeter of the parking lot where it's needed. Those are the 3 conditions that we're recommending. So happy to answer your question. The appellant is here as well, can address questions.
Jason, just briefly with item 3, the 6-inch tall curb around the perimeter, then on that southwest 9th side where we have kind of the sawtooth of the angled parking, would you want a 6-inch stop bumper then in front of each stall?
Yeah, I think you would need to keep a vehicle out of that.
Because otherwise
area.
it'd push over into whatever that potential
Exactly,
landscape.
or into,
Okay.
even worse, into the sidewalk.
Sure, and then on the part where there's already that white existing fence, would you want the perimeter curbing in front of that?
I've just learned from talking to the appellant that he has kind of an arrangement or agreement with the other property owner, and so I guess I would ask the board to hear his concerns with that before you would move forward. But the way the staff recommendation is written, it would require a curb along this perimeter too, but I think that we'd be open to.
Yeah, I just maybe want to clarify some of that logistically, because it could help then channel stormwater, maybe a little different than how it's handled now as
Sure.
well. And I don't know where that would shove water based on contours on the site. I know it's kind of flat, but thank you.
Thank you. Applicant or representative of the applicant?
I am Richard Fry, Iowa State Bank, 627 East Locust Street, Des Moines. With me is Nick Iria. Iowa State Bank acquired this through a friendly, it was not a foreclosure, but just they deeded it back over to us. This property's been a made right for probably 20 years, Southwest 9th made right. It has sat vacant about 2 years now. And Iowa State Bank is going to lease the property to Nick. Nick is going to do some improvements to the property, put a new 1,000-gallon grease interceptor in, and do some other improvements to the property. We will be signing a 1-year lease with a 1-year option, with a option to purchase the property. So I'll turn it over to Nick.
Good afternoon. Nick Iria, 1807 75th Street. The city seems to be in favor of all the variances on the setbacks, something that's necessary in order to meet the mandatory space requirements, parking stall requirements per square footage of the building as restaurant use. A couple of the things that I'm having a slight issue with is that right here, there's actually a sign there. It has a pretty wide 4-foot pillar that sign sits on. If you go, there would be only a very small portion of it that you could actually pull up and put sod into that area without jeopardizing the integrity of the sign itself. What looks like a great deal of space right here in this area, there's a 0 lot line. There is a 6-inch curb which goes all the way around this section. There are 2 small areas that need repaired, and I'd be willing, I'm going to go ahead and repair those, obviously clean up the weeds that you saw and things of that nature. Just past the curb, there is about 6 inches that allows for the overhang of the car so that it doesn't intrude on the actual sidewalk itself. So in a perfect scenario, this little space right here where they're asking for a shrub, once your tire chalk's up there, which gives you this 10-foot of section, there's really only 6 inches of green space that you could put there. You wouldn't be able to put a bush or anything in that nature. When your car is actually in there and parking, both tires are right at it. You have about 6 inches that the left front wheel wouldn't touch that curb. And then to proceed back into the back section, 2.5 foot of this section here is owned by Alan Anania, who's given permission upon a leasing agreement that I pay a dollar amount per month to use his 2.5 feet to use those as parking stalls. Without these parking stalls, it's going to be real tough to make, again, the required parking spaces in order for restaurant use. On this back section, there's actually no curb back there, but in order for Alan to lease me the property, he wants me to put up a 3-foot fence, and what that does is it stops the cars from hitting his fence. So to have the 3-foot fence and a curb in that section is just, why do it twice? It's kind of a waste of money. So those are my issues. Those are the only issues that I have. Without the variances of the setbacks, the building won't meet the parking requirements for a restaurant. So I'm asking for the variances, and I'm also asking for you to deny the staff recommendations of those 3 units as they're unnecessary.
Okay, go ahead.
Nick, what kind of restaurant are you planning to reopen here?
It's going to be a sandwich shop again. It
Okay.
will not be a maid right.
Okay.
It'll be my sandwich shop, but it's going to be in the same fashion. The building was remodeled on the inside, so it actually looks really nice. We're going to keep everything just the way
Okay.
it was.
And you've got indoor seating there besides the drive-through thing?
There's 49 spaces.
Really?
49 seats available, yes.
Okay, okay. You mentioned that, requiring the curbing on what I'm going to call the west perimeter along with your 3-foot fence would be kind of silly, which I would generally agree with. But would the curbing by itself be cheaper? And if so, would that make Mr., I think Anania, is that right?
Right.
Would that make him happy enough that if somebody hits the curb and you've got some gap in there, then they wouldn't hit his fence? Or would he rather see them push the fence on your side first?
It would actually be less aesthetically pleasing if you put chalks, 2 feet behind the edge of that drop-off. If I'm allowed to put a nice fence up
You'd rather have a fence? Okay.
It's going to look better. It's
Okay.
going to look better. It should please the city a little bit more.
Okay.
Because without the fence, it's kind of like a cut-off piece of cement that just drops
Okay.
into some grass.
And if we don't require, let's say, bushes per se on that east, or on your east perimeter onto Southwest 9th, could you still come up with some green space that's maintained just with grass, or are you saying there's really not even room to even do that?
There's really not an option.
Okay.
And to try to get a 6-inch piece of grass to grow in asphalt, which heats up tremendously in the
Sure.
summertime, it's just not going to work.
So what about a really nice flower bed around that 4-foot sign?
That's what I wanted to ask you, if that would be acceptable. Instead of going down to the sod, if you'd allow me to, around the sign, to build up a flower bed, maybe put something in there instead.
Maybe you could put that on, if you're putting that on the table?
I'll put that on the table.
Okay. Okay, that's all the questions I have.
Any other questions for the applicant? Okay, thank you. Is there anybody else to speak in favor of the application? Is there anybody here that is opposed? Okay, we'll close the public hearing and go to board deliberation.
Can I ask the staff to just put the photo up that showed kind of how that signpost and that Southwest 9th right-of-way looks? Okay.
Oh, I see, there's a pole sign there in the northeast corner.
It's hard to see the footing for that.
Right, it's probably in, the asphalt's poured around the footing for it.
It actually comes to the top of the asphalt is where the actual footing itself, so it's all the way up to the top and the asphalt's around the footing.
You can kind of make out a shadow along here.
Here's my question, will he be able to keep that sign since it's
Yeah.
not been in use for 2 years? Does he have to do another?
That's not before us.
I know, but
Yeah, I believe that he has, that zoning in place would allow the sign, so.
The size of the sign would be allowed.
Not conforming, other than there's no use in the building.
okay, so
Right.
it's, okay.
But the sign pole could stay there then, right? Theoretically. All right.
Could I have a motion here?
Well, depending on what everybody else thinks, I think one of the goals we're, I think, generally trying to get at is help everybody improve the look and get them into the property to get it used, but also improve the looks, especially in these commercial corridors. I drive by this one a lot. It doesn't look very good sitting there empty, but it doesn't look very good with just all paving. I'd like to see a little raised flower bed around there in lieu of requiring him to have these sawtoothed little landscaped areas there on 9th. So maybe we could figure out, he takes that hatched area that's already there, and then I don't know if he'd square that out a little there on the.
Perhaps if you wanted to strike paragraph 1 and in lieu thereof, say that the
Yes.
the
Shall be
excess
removed.
payment at the northeast corner of the property shall be removed and replaced with a flower bed and sod.
Yes. Yeah, with a flower bed and/or sod. If he wants to have nice grass and he'll mow it, great, but if he puts in some decent perennials, then he can take care of it and it won't take a lot of maintenance.
And then perhaps in item 3, instead of saying a 6-inch tall curb shall be provided around the perimeter of the lot. You could say shall be provided around the perimeter of the parking lot except on the west side where a fence shall be installed.
Yeah, I think it's important to still keep the cars off the sidewalk on the Southwest 9th side. Actually,
Use what? Okay. Is that in the form of a motion?
yeah, but the discussion about the flower bed would go to item 2, I believe. That is the northeast corner of the property, right?
Right.
Okay.
Yeah, I have you striking 1, which
Yes.
was the, and then 2, I believe you said sod or
Yes.
planter bed, raised planter
Right.
bed.
I would move what Jason just wrote down there.
And
Is that good enough?
Sure.
Okay.
except for the property line.
I'll second.
It's been moved and seconded to accept the staff amended recommendation for the item. All those in favor signify by saying aye. Aye. All opposed? It passes 6-0. Okay. Number 20, the Teach Out Properties at 500 East Locust, request for a conditional use permit.
And I'll give you the cards here.
Sixth floor.
I do have police reports for the area, if you're interested in those, and did those get sent out to you in your packets? Okay.
Yep.
The request here is for packaged alcohol to be sold as part of another business that would involve, I think, retail sales of furniture. Therefore, it requires a conditional use. We treat this as a limited retail use under the current provisions for businesses selling liquor, wine, or beer. In reviewing this, there have been previous conditional uses granted in the teach-out building. The underground is currently there, and that's for on-site consumption. There was a cooking school, I don't know if any of you recall, at one point in time that existed in the building that had also for consumption. I believe it also allowed them to sell bottles out the door as well, as part of their cooking classes, as an accessory component. Since that time, a number of other businesses have come to the area which involve the sale of liquor, wine, or beer. And if you do recall, the property just a block to the north and across the street at the southwest corner of East 5th and East Grand Avenue did come in front of you for a packaged store for liquor, wine, and beer sales. And that, for some of the same reasons, we are recommending denial of this request as well. We would look at this as an opportunity for packaged alcohol to go out the door, and that would become part of the pedestrian character. And we don't think at this point in time the character that's kind of established itself in the last few years would be conducive to allowing the packaged alcohol to go out the door. So from that standpoint, we are recommending denial because we don't think it fits the character of the pedestrian quality of the neighborhood.
Eric, I had a question. Is this the tenant or the building owner that's asking?
Well, the owner has to consent to this, so we always put them but it is a tenant that wants to do the use.
So if the tenant's in there and it was granted, would it end with the tenant?
It wouldn't necessarily unless you qualified it to that extent. I mean, the better thing to do would be to limit it to the same, as accessory to a certain type of use, where if let's say that tenant sold the business to somebody else and they wanted to continue to operate that use.
But my concern is I'm not disagreeing with staff recommendations, but if the board granted it, we're in one case, we're granting the whole building to have a liquor license?
No, no, no. It would still be limited to that premises that they're requesting it for that particular business.
So it's limited to that
Right.
6th floor or whatever or something?
Yes. And so, the 6th floor retail space would be the area that it would.
I just want to make sure I understood.
And again, if you qualified it to sunset with the use or the type of use, or I think that would be a better approach to it than to the particular operator, because I think we get into a little bit of hot water if we just tie it to the operator itself. The liquor license is something completely different. That could be tied to the operator.
Eric, you had mentioned something earlier about we had reviewed like a packaged liquor store.
Yes, up in this property here.
Yeah, and we had denied that, correct?
Yes, that was
Now,
denied.
that was a case where they were going to sell not just wine, like this proposal, they were going to sell,
It was going to be
liquor.
a small grocery / beer, wine, liquor.
And with a drive-through, if I remember right, and open 24 hours.
I don't remember the drive-through.
Okay, I thought they were going to,
Because drive-through would take another variance.
well, it was maybe not drive-through, but it was going to be 24 hours, wasn't it?
Yeah, but the zoning would allow any kind of business to be open 24 hours.
Okay,
so.
okay. Yeah, I was just curious, but I think the proposal was a 24-hour walk-in liquor store, right?
That, I think, was the original consideration.
All right.
And they framed it in terms of it being like a small grocery or bodega or whatever
Okay.
you want to call it.
Okay, all right. I'd like to see how this appellant compares, so.
But from our perspective, we believe the same basis which we recommended denial of this location is valid here. When we start presenting packaged liquor or wine out to the street with the pedestrian character that's that's evolved.
Okay.
That we're now facing something different than we might have 4 or 5 years ago.
Okay.
In terms of the character.
Eric, your understanding of the request for the conditional use permit then is not for on-premises consumption, but it's as for off-premises consumption. In other words, they're selling only bottles.
Right, they want to
of
sell
wine.
it so you can carry it out the door.
Yes, and they are not sitting people down to look at a couch and giving them a glass of wine and saying,
Well,
now do you like it better?
They may be offering it
free,
complimentary wise, but they're not selling it to them to consume on premises, no. And I know we've been into that tasting kind of thing before, so.
Yes.
Your understanding is that they are not serving on premises, is that right?
I don't think that they're not serving for sale, no. I don't.
So it's a packaged liquor store is what it is?
It's a packaged goods wine, yeah.
Except that they can't sell more than 40% of everything they sell.
Right.
Less than 40% has
Their
to
primary
be
use is
liquor.
still the retail component of the furniture, yes.
Okay.
Thank you. Applicant or representative of the applicant?
Mr. Chair, members of the board, Todd Von Steen, Design Co., 118 Southeast 4th in Des Moines. To talk a little bit about Vintage, it is just a mid-century modern furniture and accessory store that provides furniture such as couches, stereos. We have a few accessories of ties, vintage ties, cowboy boots. There are vintage hats. There's the intent behind the wine is to drive a little bit more traffic to the space. The wine is the wine holder and the 100% business owner is an experienced wine. Oh, can I see your book? Wine license holder. Peggy has held a wine license, the Class B native wine license, previous to this, and is experienced in the levels of sampling that can be done, which is pretty minimal. There's not going to be any glasses of wine passed out for people touring around the store. That's just not allowed by the permit. And also, I just wanted to address one more thing real quick on page 52. Part of the permit development, the electrical inspection's already been done, so part of the process has already been completed successfully. I want to make a quick note on that. Also, as far as packaged sales in East Village, Sticks Gallery, also a furniture store and accessories, does have a Class B wine permit for package sales. And so there is clearly no difference between that permit and this permit. It's a furniture and accessory store that's providing Class B Iowa native wine. When we look at baby boomers also had a permit for carry-out wine. You'll see the privileges is Class B wine permit, carry-out wine. And baby boomers is now, of course, they've moved and they've closed up and moved to Denver, which was good for them. So what we've done is we've lost one carry-out wine place, and we're trying to fill that void with another one. And sticking to Iowa products. And part of the staff report talked about density and how we haven't seen carry-out wine or packaged wine in these dense kind of areas where there's 7 taverns. Clearly, Sticks is one that's in the area, so we do see the density. And also, carry-out wine is at Sobraco, where you'll find higher density for carry-out packaged wine. And that is not just Iowa wine. That's all wine. Vintage is staying focused on Iowa wine. Some of the discussion points that are on the page right before the plan. Vintage, the hours of vintage clearly can't be part of the bar scene. It's 10 to 6 daily, on first Fridays till 8, to be in spirit with the neighborhood. Again, Iowa wine's only for off-premise consumption. Our target market is not anything to do with, it really, what we see coming through the door right now at Vintage are out-of-town, out-of-state type customers coming through. A few from the neighborhood that have been excited about this. And at this point, I haven't heard any resistance from the neighborhood association, neighbors. I haven't heard any resistance. Everybody that's been through Vintage has been excited, and sales are continuing to grow. And I don't think we need to mention, it's kind of a no-brainer, but selling Iowa wine supports the economy by promoting the businesses and small businesses in Iowa. Vintage is also an extension of a small company in Humiston called Whittle Doddles, which Peggy is also 100% owner of. And basically, this is another way for Whittle Doddles to remain viable in such a small community. It's the same type of a store down there we're going to sell. It's kind of the same model, although this is mid-century modern. And Whittle Doddles is a little bit more diverse because of its location, of course. You can see in number 5 kind of the other products that we'll be offering that also fall into the homegrown theme. Bird feed, feeders, barbecue sauces. So all of these products, Iowa products or Midwest products, will be offered as well as the Iowa wine. Right now, Whittle Doddles, the model that we're using, the average total revenue from wine is about 15%. And I can't anticipate any way that would exceed that. And at the bottom just talks about Vintage is an eclectic and fun mix of mid-century real estate finds. And all we're really doing is finding stuff from around Iowa, bringing it and redistributing it to the new generation, really.
You gonna have your own TV show?
No, but we're trying to get a black and white TV rigged up that'll play black and white movies all day.
Cool.
So, yeah, and then what I really want to do is spin it out in the window at night, but...
Sure, well, you know.
Yeah. And I'm not sure, do you have any questions for me?
No. Is there any questions for the applicant? No. Thank you. Is there anybody else to speak on behalf of the applicant? Is there anybody? Go ahead.
Hi, my name's Peggy Rash, and I do own a store in southern Iowa called Whittle Doddles that I am modeling Vintage after. The difference is Humiston is a town of like 500 people, but one of the things that attracted me to East Village was the small town feel. And as I look at the people in the middle of the afternoon shopping, it's much the same as it is in Humiston. And those people just want to enjoy an afternoon and take something back home with them that signifies Iowa. And Iowa wine is just one of those options for them. I know that the conditional use permit doesn't designate between any wines and Iowa wine, but this is just, the only thing I'm interested in is Iowa wines. So nothing else beyond that. So if anybody has any questions.
Does anybody have any questions of the applicant? Okay, thank you very much. Is there anybody else to speak on behalf of the application? Is there anybody here to object to the application? Yes, step forward.
Hello, my name is Sam Erickson. I'm the Vice President of Community Housing Initiatives, which is the business that operates at 500 East Locust on the 5th floor. I came today to talk to you a little bit about the concentration of liquor in the East Village and also the state of the building that is the Teach Out building. Teach Out building is a turn-of-the-century building. We have a fire escape which cannot support the weight of me. I've tried. We also have only one set of stairs. The building is not sprinkled. We're on the 6th floor, and we have an elevator that works intermittently on that location. I've been in the present space on the 5th floor for 7 years. We have liquor license in the basement. We have Woolies, which is next door but is attached to our building through a walkway and also shares our restroom facilities. And we also have a wedding facility which frequently hosts large events on the weekends. We have an extremely high concentration of alcohol in that area and in that building. In the course of the last few years, I've found numerous unmentionables because there is nothing securing the rest of the building from all of these alcohol activities. Really bad things in our hallway all the time. One evening I worked until 1 o'clock in the morning, Sunday morning, and there were 3 different couples of people who pulled on my door trying to get into my business. So this is not a very secure area, and there are 5 other businesses that are currently operating from this location. We are strongly opposed to adding another liquor license to the 6th floor. It sounds like a very nice proposal, and I'm sure that their intent is very good, but the applicant, who is our landlord, is Kirk Blunk. He's not here, and the license is not restricted to just Iowa wines according to the law, which would open it up to virtually anything, I'm afraid, after they left. This space has had significant turnover. In fact, it's been operated as a private residence since 2005. Until recently, it is not zoned for that purpose. So based on a lot of things that have gone on in that building and in that property, I'm going to strongly encourage you to take the staff recommendation and deny this liquor license. I'd also like to add that there have already been, for Vintage, numerous signs that indicate free wine is available on the 6th floor. And I, again, very respectful of Iowa wines. I'm a fan of wine myself, but we're already selling it a block down the street in addition to all the other venues that are there. In light of the hazardous conditions of the building, we'd like to encourage you to deny this. Thank you.
Thank you. Is there anybody else here to speak against the application?
Hi.
Hi.
My name is Julia Tallarico. I am the manager of Velvet Coat at 500 East Locust, the 1st floor of the Teach Out building. We have been there for 5+ years. I am here representing the owners, Connie Parsons, Michelle Galvin, who are in Iowa City. I would like to just reiterate everything Sam said. I have a folder here of alcohol-related incidences that have happened in the Teach Out building in the last 5 years that I have personally been there, not to mention break-ins, breaches in security. When the underground bar opened in the Teach Out building, which is directly below me, the owners of Velvet Coat were promised that there would be security at all times in the building. and there has never been any security. I too have found many unmentionable things related to inebriation and alcohol, and I also am concerned about, on the third floor of the venue that Sam spoke of, there is a lot of activity that goes on up there, not just weddings, private parties that have a lot of alcohol, parties that are advertised to be there till 5 o'clock in the morning. All kinds of things like that. So in trying to run a business in that area, I know Todd, I like Todd, I hope his business, makes it, but I do not want to see any more alcohol license in any of the buildings owned by Kirk Blunt. And I do have concern as well for if he leaves, what happens to that alcohol license. I'm very familiar with, we own a restaurant ourselves, so I know about, alcohol and all that too, and how hard it is to get a license, but I am concerned that that would continue to be a license that somebody else could take over.
When is your lease up?
When is our lease up?
I wanted to ask Sam the same thing.
Like I said,
Just teasing.
we've been there, both of us have been there long enough to experience a lot of the things that, go on, and we're trying to make this a lovely multi-use neighborhood, as the gentleman spoke of first, a pedestrian-friendly neighborhood. There is certainly enough alcohol to go around down there, and I understand the whole concept of selling wine, but in selling wine, you do open bottles of wine, and there is a lot of consumption. So, and especially if it doesn't, it's kind of my understanding, one of you had read that it doesn't mean that it's just is it my understanding that if you have a wine license, it's all-inclusive? Or is it just limited to wine? Is there any delineation between wine, beer, and hard liquor?
I can answer that. Yeah, can the city staff please provide an answer to that?
Yeah.
I think I'm done unless you have any questions for me. One of my main concerns is that, like I said, we were promised that there would be security in the building, and I can give you many instances of problems that we've had, and it is directly related to all the alcohol consumption in the 300 square foot radius around our building.
Okay.
Thank you.
Thank you. Is there anybody else to speak against the proposal? All right. Mr. Von Stein or Ms. Rash, you have 3 minutes.
Peggy, Ms. Rash has applied for a Class B native wine permit. So I don't know the restrictions to that, but I can tell you that the application is for a Class B native wine permit. And there are wine tastings that go on the first Fridays, we bring 3 wineries. Vintage will bring 3 wineries in, Iowa wineries in, to do wine tastings.
Now, you didn't tell us
I'm
that
glad
earlier.
you brought that up.
You didn't tell us that earlier in your
Well, the wine tastings are
presentation.
still limited to the same as the sampling. The wine tastings, you only do a half ounce, but Peggy, you'll have to speak more to that. But
Okay.
there are wine tastings that go on. But again, you're only limited to 3 total ounces, or Peggy can speak to that. But we do bring 3 of the Iowa wineries in to promote their products every first Friday. But we'll let Peggy talk about that. Oh, sorry.
Yeah. Before you finish up, I'd like to have Sue Ann Donovan come up, and she seems to be aware of the current regulations regarding conditional use permits.
There are permits that are specific to native wine. If you give a conditional use permit to allow alcohol sales on the 6th floor, it would not necessarily mean that somebody couldn't then apply for a different type of liquor license at some point in the future, unless the conditional use permit was so crafted so that it was only for a permit to sell native wines.
So we could, in your opinion, grant a conditional use permit for a Class B native wine permit only?
Yes, and if they requested a different type of permit, we would be able to deny that based on the conditional use permit.
Okay.
And the conditional question for Sue, the conditional use permit request in this case
It's a general one.
is a general one being requested by Teach Out Properties, correct?
Correct.
So if these folks split and left, that conditional use permit could still apply to someone else then coming in if we did issue it with Native Wines, and they could sell it too?
Correct.
Okay.
However
If they had their separate liquor license as well.
However you craft the conditional use
Okay.
permit, it runs with the property unless there's a lapse in use. And a new tenant, new occupant could come in under that conditional use permit and be allowed to operate
Okay.
as the conditional use permit sets out.
Unless we specify we only want it in one person's name or something like that, we can do that?
I defer to
no.
legal, but I
No.
believe that you.
No, because you're issuing it to an LLC.
Okay, gotcha.
Right.
Okay.
Question. Does a private party does a building owner have to have a liquor permit?
The permits would be issued not to the whole building, but to the area that the liquor sales were in.
No, I mean, one of the ladies mentioned that there were several private parties or wedding receptions, and there's obviously alcohol. So does a building owner have to have a liquor permit for that?
The entire building, under the ownership of the building owner, would not necessarily need to get a permit, but he could sublet to a tenant who went in and got a permit for a certain square footage of his building.
The answer to your question is no.
No.
Okay.
But for those things to occur as they have, those things would need permits and licenses to have parties where liquor's being served. Somebody has to have a permit or a license for
Yes.
that, right?
Correct, for that particular defined area
Yes,
within the
okay.
building, yes.
Okay.
Thank you, Sue Ann. Ms. Rash, you have 2 more minutes.
First of all, it's my understanding that the application, permit, license goes to me. Once I am gone, there is no more selling Iowa wine. And I would just also like to say that we would be in agreement with stipulating that it be for Iowa wine only. No intentions of anything else.
What if we stipulated that it could only be 15% of your overall sales? According to conditional use permit, or conditional use permits are required if it can be no more than 40%, if I'm correct. But what if we decided to limit you to no more than 15%, as you said was typical in your other venture? Would you be okay with that?
I don't look for it to be any more than that.
Okay, okay.
Yeah.
Okay,
It would
just kind of curious. Thank you.
Yes. Any other comments?
That's different.
So I have no intentions of anything happening. The only access to the 6th floor is by elevator and then the stairway, so I don't foresee any of our people as they're going down, stopping the elevator on the 3rd floor between the hours of 10 and 6 to do any illegal activity. But we will do everything that we can to avoid and keep it under close watch. So I don't want any problems either.
Okay. Thank you very much. Is there anybody else to speak? All right. We'll now close the public hearing and go to board consideration. Well, it seems to me we got 2 things to decide. Number 1, is anybody inclined to grant the conditional use permit at all? And then number 2, if you are, do you want to limit it? Okay? So.
Who are we granting the permit to?
In this particular case, it is entitled Teach Out Properties LLC, but Vintage LLC is really the real true party in interest and would be granted to Teach Out on that square footage on the 6th floor. Okay?
Okay.
The license would go to Vintage.
Hmm?
The license would go to Vintage, and if another company came in on their heels, it could be a different company that would get a license.
So it would only go to the Vintage LLC?
Well, the use would stay with the teach-out properties of the premises. And the
For the square footage
licensing
on
could
the
change names
sixth
over
floor.
time. But you could limit it to the type of license or the type of product sold, or however you want to limit that. So if you wanted to say native wine only, then we would only be able to issue the native wine license.
Right. So, comments. Do you have any comment
Well,
about whether
I
or
have
not
a-
they ought to have any conditional use
I
permit?
have a comment. It seems like a nice business. My concern is what some of the other property owners or leaseors brought up, and I'm still not clear on if I rent a space and to have private parties, if you need a liquor license or not. I don't know if that was clearly answered. But if we give the teach-out building this liquor license, seems like an opportunity to just keep circumventing certain issues that was brought up. Nothing against these people and their business. I'm just somewhat confused on how this liquor license thing works, and some of the concerns that have been expressed.
Right. It is a conditional use permit. A separate application occurs with a separate body through the city council for the liquor license.
That's correct.
Right,
In other words,
right.
all we are doing is giving a permit to them to go obtain a license. And the permit is located, is before us, is for the
Right.
sixth floor of the teach-out building.
And our conditional use permit could be transferable to other, quote, liquor license operators.
The conditional use permit stays with the building.
Right.
In that square footage.
Only on that floor and that square
Yes,
footage.
that's right.
And I think there's the issue.
Yeah, the issue is that you want to consider first is, do we want another conditional use permit in the teach-out building?
Right. By itself, this would not seem like a big deal to me. In fact, I was surprised the recommendation was no, and I was surprised that some very nice businesses are very much against it. But it sounds like on floors 1 through 5, it's what's behind the green door. You just don't know what party you'll get in the middle of in this building. I think the use by itself would be pretty innocuous. But put it into the mix of what's going on, I don't know if we'd be adding fuel to the fire here, or if these people, they're gone by 6 o'clock, they're hoity-toities from Glen Oaks, and they've bought their Americana vintage stuff to hang in their garage, and they're gone, which is probably actually what would happen. But it seems like the elevators and the staircases go up and down, and everything gets mixed around, and then it gets confusing. And we approved the underground's conditional use permit 5 years ago.
Yes, but the real question, I think the real discussion ought to be, is there enough conditional use
Okay.
permits in the teach-out building already? In other words, do you want to have another one in that building? Because, we've got two kind of long-term tenants that say, we don't want this use here. They're neighbors, it's a neighborhood,
I'm very surprised by that. If it was a very limited amount and a very limited kind, I still might not be too concerned, but it's just, that's why we're here to talk about it.
Jake, do you have anything?
I think that the use itself, if in any other building in the East Village, I would support. I think what was presented to us in terms of the business is a reasonable, it's not a carry-out, 40-ounce beer in a brown paper bag. We're talking about a bottle of wine between 10 and 6. I don't have a problem with that. The issue, I think, that we're dancing around is a problem landlord in a building that has issues unrelated to this business request. And so how do we mitigate future exposure? My biggest concern is once this business, if it's no longer in that space, that building having the ability to continue a more problematic use. And I agree with you that the building is a neighborhood, and there are people within the building who are not in favor of it, so I do give a lot of credence to that opinion.
Linda?
I agree with what everything has been said, or what Jay said previously. I just don't think, I feel bad for the business. I think it sounds like it's great business, but it's a landlord issue. And it's just, we have good tenants that are there. They've been there for a long time. They're saying it's just not appropriate. Maybe if Vintage wants to be in business for a couple of years and then we can see how it's going, but I'm going to support staff recommendations today.
Cindy?
I think it's a bit concerning I feel like we may be penalizing this particular Vintage LLC because of poor landlord management. Have we heard about issues in the past? I know we're hearing that. I believe them.
Mm-hmm.
Is there some kind of enforcement that should be done?
Well, I think we need to investigate what some of these things are in terms of, I'm not aware of any assembly occupancies on the upper floors of this building. Now, we did grant conditional use next door, and that's a venue. Now, what I'm hearing is that maybe they're sharing the restroom corridor as part of that business. If there's other activities happening in this building, we may need to investigate those from an occupant, probably more from a building occupancy than anything. Then secondarily, if they're selling liquor or alcohol, then we have to look at it from that standpoint. But there isn't any other conditional uses that have been previously granted other than the underground.
Are you saying there's not an assembly use on the second floor of the Hoburger?
Of the Hoburger, yes.
Which is the same property. They share the same
Right.
stair and the same elevator, right?
Right, but within the teach-out building itself, I'm not aware of anything on the.
But wouldn't you
That wasn't
review?
something that we've reviewed at the board.
Wouldn't you review that at the same level, though? I mean, when two buildings share the
They
primary
might
egress?
include the stair corridor or something as meeting the building code requirements.
Okay.
But what I'm saying is we didn't have a conditional use to allow assembly space in the upper floors of the teach-out building.
Right, okay.
And so,
But there is,
and I can't, that's why I'm saying we need to investigate, is this activity in the Hoburger and it's spilling over into the bathroom access and stair corridor, or is it something else? So,
I don't know if you can for the code, but that is one building. There's one stair tower.
I don't know how it was looked at over time with these different occupancies, and so I can't really speak to that standing right here.
Sue Ann, do you have a comment?
I guess I'd just like to say that anything that goes in there is going to have to meet building code for renovation. I know that things have moved in and out of this building.
How's the
I'm
fire
not always
escape?
sure that they're always approved before they move in and out.
Okay.
So I want to make sure that whatever you do is tied to the building permits and meeting egress and sprinkling and whatever needs to be met as part of the conditional use.
Quick question for staff, Mr. Chair, if I may.
Go ahead.
Could Vintage LLC come as the appellant directly and requested the conditional use permit in their name? Or does it have to be?
I see them as the operator, and
right.
Certainly they're tied to the license.
Right.
And you could have multiple series of licensees over time within this use, continuous use.
But if they had wanted to, could they have done that? Are conditional use permits just granted to the property
I don't see them as being
owner?
able to have their own legal standing to grant the use. They don't have power to accept zoning terms.
Okay, that's what, so conditional use permits go to property owners usually, is that correct?
That's right.
Okay,
Because if
all
they
right.
leave, they can't take it with them.
That's all I need to know. Okay.
Yeah, it's not transferable anywhere else.
Okay.
Any other comments? Does anybody have a motion? Well, that certainly takes care of it.
Move staff recommendations.
All right.
One question, if I could.
Go ahead.
Didn't somebody mention limiting a potential approval to only this use, this person, this entity?
You could limit the conditional use permit to a licensee who only has a Class B native wine permit, if you wish to do so, okay? But first you have to understand that you are allowing another alcoholic use in the teach-out building. And the question really is, staff recommendation is denies the conditional use permit. Okay. Now, it's been moved, but it has not been seconded. Is there a second to the motion? Okay. The motion dies for lack of a second. Is there any other motion?
I'm not sure what to move, but I just think we're missing an opportunity here to try to help fix a problem.
Okay. What would staff recommend if the sense of the board was that we wanted to grant some conditional use permit for this building?
I think the chair was headed the right path. You want to tie it to type of product sold. Hours of operation was, I heard.
Could we limit the percentage of sales?
Yes, I think you could limit the percentage.
That's pretty hard to administer.
It's hard to,
But the
it's hard to
40%
enforce.
is just as hard to administer,
It's
isn't
hard
it?
to enforce. I mean, we have a
Yeah.
standard already for conditional uses applied to limited retail, which is 40%.
Right. But it's just another warning
It'll be
sign.
something else we would have to really actively enforce.
Well, you have to actively enforce the 40% too, right?
Or
Or
when
is
I
that
say
easier
actively,
to
we'll have
tell?
to treat it differently
Is
than
that
our other
easier to
situations,
tell?
yeah. 40% is at a threshold that probably is going to be more detectable than 15%. But,
And I think when you sell couches, it's really, you could sell a lot of alcohol at 15% of a couch sale. We're talking about a lot of alcohol if that's the measurement. I don't think that's the
These are
power.
expensive, nice couches. They're mid-century modern.
That's what I'm saying, is
Yeah.
that 15% of a
Oh, it
$1,000
already
couch
gives
is a
us
lot of alcohol. I don't think that's the way to,
It's Americana.
I'm going to
Goes for big
backtrack a little bit. Is there a way to,
This isn't flea market stuff.
the real issue seems to be the other businesses, and I'm backtracking now. I think adding alcohol could be problematic without fixing the real issue in the building. So you talked about enforcement. How is the building being enforced now? Is there any effort to curb the issues that are in the building currently?
I guess I'm not sure if there's any history of complaint that we've been managing, but certainly everything needs to meet occupancy. If there's, private parties where people are bringing their own alcohol, it starts to become an assembly function if you're not careful. I don't know if it's skirting around the bounds of that. We'd have to do some investigation to be able to figure that out, but it sounds like there's problems, so.
I'm new to this game. Can we push this for 30 days and get an answer to that question?
You have a good question.
Again, there's not something that we're going to be able to settle right here today to know what.
I'm asking if we can move this. This is my third meeting, so forgive me if I'm wrong. Can we push this 30 days and get an answer?
30 days, you could push
or
it 60 days, you could push it
and allow
indefinitely.
what then, Jay?
I would
What
feel
happened?
more comfortable knowing the answers to the questions that you're saying you can't answer at the podium. 60 days isn't going to dramatically impair this business. And if we could get solid answers and a plan to enforce or fix the issues, to your point, I do feel like we're penalizing a
I think
business
it
that
would
isn't
queue up the
problematic.
owner of the building to be able to respond to some of these things. But
That's a big part of the issue.
I guess, and maybe you should ask the people that are here to represent the application where that puts them, just so you know.
Yeah. Well, you're suggesting that perhaps with the consent of the applicant, the matter be continued for 60 days. Is that correct?
Right.
All right. Let's hear from the applicant. It's been suggested by one of the members of the board that in order to give the city a chance to take a look at the issues that have been raised by the two tenants in the building, the matter be continued for 60 days. We cannot continue any matter unless the applicant consents to it.
Right now, the concern would be trying to get Vintage off the ground with the right marketing at the get-go. So 60 days is a long ways away for a new business to change its identity. So that would be one penalty of that would be from this 60 days. 30 days is at least you can get through 30 days with your identity still in place and change some signage and change some business cards and stuff that, no big deal that we were trying to put the concept out with. So 30 days, we don't really hit an identity mark as much as we do in 60 days. That's through the summer, and there's a lot of traffic through East Village in the next 60 days. So it's quite a penalty to go 30 days. 60 days changes the identity to thousands of people that will be through East Village. So that's kind of I appreciate what Jake's saying, but when I look at identity and getting off the ground and the need for success in this venue, that's quite a hit for the identity. And I mean, 30 days, at least we can get through that, although there'll be a lot of people down here through the next 30 days, granted, but I still think the enforcement can happen one way or the other without this. I mean, whether you grant this or don't grant this landlord isn't going to that's not what's going to budge him. It's going to be different types of enforcement that will make him change, not this. He's not going to look at this as anything. So I don't think this is going to have an impact on that landlord. I really think it's going to take a much bigger hammer than this.
Todd, have you already signed your lease agreement?
Yeah.
Okay.
And we're trying to rewrite it for 5 year with 5 year options behind it, so that we trying to make sure that something with this landlord doesn't fall out from under us.
And what you're saying, the identity of your business, being able to sell wine, even in whatever percentage, that's a big part of your identity. Is that right?
Well, it's 15% of it at this point. That's big in a small business.
Okay.
That's really big in a small business.
I call that a minor investor. It's
Let's stick with the.
Okay, all right.
Are you done?
Yeah, thank you.
Let me be clear with the applicant. You would like us to proceed to decide this issue? Or do you want to request a continuance for 30 days?
We'll be agreeable to 30 days.
All right. The applicant has asked for continuance for 30 days. Is there a motion to continue the matter for 30 days?
I would move to 30-day continuance.
I'll second.
Okay. It's been moved and seconded that the matter be continued for 30 days in order to allow the city time to investigate the complaints of the tenants. All those in favor signify by saying aye. All those opposed. Okay. The continuance is granted 5-1. The comments of the objectors will be considered at the next meeting, but we would, because the matter has been continued for 30 days, the next regularly scheduled meeting is
July 25th, is that right?
25th. July 25th. It's the fourth Wednesday of the month. So I would encourage you that if you do object to this, that you reiterate your objections at the July 25th meeting. Item 21, the North American Islamic Trust for special permit and variances at 6201 Frank.
The cards are going around, Chair and members of the board. This is the response map, a couple of support, opposition. Subject property, Franklin Avenue, 63rd on the northeast corner. It's a fairly large site. This is looking down 62nd Street along the east perimeter of the site, kind of looking towards the north and to the west a little bit. Subject parking lot, and then parking to the north. I'll get into the relief here in a minute. This is just looking south down that east perimeter. This is closer to the north property line where that's relevant to part of the relief request. This is a site sketch. They're requesting a few things.
We cannot see the site sketch. There it is. Okay.
Camera's tired, I guess. The first part of the request is a special permit for a temporary off-street parking area to the north. There was some, in the picture you can kind of see an existing gravel area. The other parts of the request have to do with the a variance of 25 feet less than the minimum 30 feet of front yard setback along 67th Street, or 62nd Street, excuse me. So that's where there's an existing parking lot. What happened is the applicant is doing some fundraising and trying to do some different improvements on the site. According to their application before, they brought on a design professional. They went and had that kind of professional advice. They proceeded with replacing the blacktop parking lot that had been there with a concrete parking lot. So it's a new parking lot, so they lost that right to the non-conforming setback. So they put the new concrete in up to the property line like the previous parking lot, but it was, like I said, had been completely removed. The last part of the request is a variance of the provision requiring a 6-foot tall opaque screen along the, for the property to the north for the buffering. In that picture that I showed, you can see there's a drop off in grade, and so what they're saying is that they construct, as I understand it, their fence back in here that it's really not going to do anything for the residents to the north as far as screening, because the parking lot, most of the site sits up higher than the north end of the parking lot in that property. We, as staff, are recommending approval of the special permit and of amended, well, actually, let me take a step back, and of their variance request. We think that that providing a 5-foot setback along here would be reasonable. Where that 30-foot setback comes into play is this is residentially zoned, and that has that district requires a 30-foot setback. It's a little different than our commercial properties that we've seen earlier today, where the zoning ordinance only requires a 5-foot setback for a parking lot. So in this case, they're looking for relief. They can provide that 5 feet without impacting their parking. We think that that's reasonable given the placement of the existing building and just kind of the established patterns on the site. We think that it's reasonable to give them 18 months to have a temporary parking lot until they can get their funds together. And then with regard to the fence, we think there's an opportunity, they can actually meet that requirement along the northern edge of the parking lot. So that screen wall could be constructed along here. We've had a few other places where that's happened in town, so it's not uncommon. So be happy to answer any questions.
What do you mean by that? Where would you put that fence?
The fence would be up close to the parking lot.
Could we see a consent map?
Yeah. Yeah, correct.
Jason, could we see a consent map, please?
Sure. So we had 2 in support and 1 opposition. I recall the 1 in opposition basically made a comment about just feeling that people should follow the rules, kind of type.
One of the cards though said they were in favor, but said right now they're parking all over the street.
The street or the lot?
In the street and blocking people in.
Okay. I'll let the applicant speak to that, how their center operates and their patterns. I know that I would imagine that their parking lot expansion might work towards addressing that, but I'll let them kind of speak to that.
I have a question. They've asked for a variance of the provision requiring a 6-foot tall opaque screen for the off-street parking adjoining the residential district. And yet you didn't hear anything from the property owner to the north, which is probably the only one that's going to be affected, or pretty much the only one. And the applicant has stated that it's kind of silly to put it up close to the north property line.
I'm not sure that they've considered that. That was something that came up as we developed the staff report. I don't know when they had talked to staff previously. I'm not sure what their position is on it.
Okay.
I believe from the information that I had that they felt that providing it at the property line, which would be the kind of normal order of business, would be ineffective, which I agree. But there's enough space up in here where the grade is higher, where it could be provided in close proximity to the parking lot where you would provide that screen. So I'll let them address if that is new information to them or not.
Would plantings be just as effective so that, you know, that you have the idea of screening, but it's a little, you know, less, it just looks.
Yeah, I think the key is just making sure that you have the plantings thick enough that you're blocking light and that sort of stuff all year. And I mean, that's kind of the trade-off. That's the downside. You know, shrubs and plants are more attractive than a fence. But you just have to make sure you do it right to make sure you provide that same level.
Okay. Applicant or representative of the applicant?
Hello, my name is Khaled Khan, and I'm with Newman Munson Architects, 1000 Walnut Street, Des Moines. Just to clarify, give a little bit of background on the site where we were. As the city had mentioned, essentially, when we were brought in, this used to be the surface lot that you saw in the photographs as concrete used to be asphalt pavers, and essentially that was grandfathered in. What the owner did, unbeknownst to us, was they thought they could just replace the asphalt with concrete, in a way paving the surface, clarifying it. But because they did that, they lost the grandfather clause aspect of it. Now, the facility that you see here used to be a school and a prayer hall for 5 daily prayers, and then Friday afternoon prayers, which is the larger congregational space where most of the occupants, the parking permits get utilized. Then they asked us to do an addition here, and we did the required parking for that, and then in conjunction with that, have the school be operable as well. So this was 4 years ago, and they ran into some issues in terms of fundraising. People had promised certain funds, and they weren't able to meet their obligations. So the project sort of went on hold, came back on. Now they're in a position where they've gone through 2 different contractors at this point. So where we're at this point is they're able to finish this portion of the facility. What they've done since this time is the school has relocated now. So what they're saying is this essentially becomes a storage space, or for extenuating circumstances where you need a larger space for eating or something, they might use that for the better intent of it. This space is not going to get utilized. How that affects the parking is the parking that you see north along here is no longer required if the parking that they have paved thus far here and along this area is allowed to remain existing. So what they're asking for is to allow them the permission to utilize that parking space as the required parking, so they can essentially occupy this new addition that's being done. And one of the reasons for them asking at this point is their holy month of Ramadan is coming up in mid-July, and that raises some fundraising opportunities. So the deferment of the 18 months, they're hoping that they could generate enough funds to essentially come back in and basically finish the portion of the driveway that's not being provided for, and some of the other amenities that were discussed. Regarding the fencing, obviously the site essentially slopes from this point down here and this point down towards the north, and so covering that fence along that lot line didn't make a whole lot of sense. So we had suggested with our civil engineer that we provide the required landscaping along here to provide the screening. There are a lot of taller trees along here too that would mitigate any light pollution that you would get to the neighbors to the north. And then on the east side, what we were proposing was essentially saw cutting portions of the parking space that is there, essentially shifting the parking further west. I think there's enough, we've discussed with the city that there's enough circulation there that the cars can get in and out, but still provide a fence there and the required landscaping for that area as well.
Have you read the staff recommendation?
Yes.
And are you in a basic agreement with the staff recommendation?
Yes.
All right. And the only thing that is that you've requested a variance of the provision requiring a 6-foot-tall opaque screen. The city has stated that they would consider, screening closer to the parking area.
Correct.
And that's acceptable to you?
Yeah, that's what we had discussed with them. We had provided that option because to us, we would have done it on the lot line too, but it just, to us, it didn't serve the purpose, the intended purpose of the clause in terms of screening the cars, because the cars are so much higher than where the fence would be, so.
Okay, thank you. Is there anybody else to speak in favor of the application? Mr. Khan, if you've used those in your presentation, we have to keep them, or at least get a copy of them. Okay? Is there anybody here to speak in opposition to the application? Any last comments from staff?
No, opaque, just to clarify, opaque screen doesn't necessarily mean that it has to be a fence. We've worked out deals where it can be really dense landscaping, evergreen trees, double row, that kind of thing. So there is a little flexibility there.
Yeah.
Just point that out for the applicant.
If you'll look at your staff recommendation, there doesn't seem to be anything in here about 18 months.
Just the special permit is for a special permit for 18 months, so it's recommend approval of the special permit and the variance, subject to just compliance with the site plan.
All right.
And then getting permits.
Okay.
Unless otherwise specified, the special permit is 18 months.
All right. Thank you. We'll close the public hearing and go to staff, or go to board consideration.
We move staff recommendations. Everybody agrees with it.
Okay.
Second.
Okay, it's been moved and seconded. Staff recommendation has been moved and seconded. All those in favor signify by saying aye. All those opposed, passes 6-0. All right. Item 22, Seidenfield, Inc., regarding a conditional use permit at 918 Southeast 21st Street.
Mr. Chair, members of the board, you've probably seen this property a few times recently. This is really just an amendment to a previously granted conditional use that allowed this building and salvage activity, recycling activity on the property. A secondary user or a tenant is looking to use basically the remainder of the site for outdoor storage of salvage material, appliances, and a kind of a recycling and salvaging operation as an extension of another location that they have that's a legal location in the area. Just a different activity they don't want to have going on their other property. And I'll let them explain that. What they are proposing to meet the criteria for having the dustless surface. Sure. So if you can see here, currently the drive is paved into this point, and then they're proposing to extend that to get maneuvering into storing on this area and on this area down here. And that would be a recycled asphalt material. Now, based on what's shown, we still have a concern we need to meet the open space requirement for the overall site under our site plan regulations, and then that involves plant materials. So that would be the only thing. Otherwise, it generally complies. We believe this is a location that's not going to provide a lot of impact on any residential areas or visual corridors. It's far enough away from visual areas from the new connector that's being proposed. So the location in itself is not a problem from the usage standpoint, and it's zoned correctly to allow that. By putting the recycled material to where the storage is going to occur and paving the maneuvering areas, the only thing that we want to make sure happens is then getting that landscaping. And so we're recommending in favor of this, subject to the standards that you see there. Any site shall be done in accordance with the site plan, which would really be this document with some modification to show their landscaping. There might be some drainage calcs and things that have to be done based on the surfaces that they're proposing. Any site plan shall note that the junk and salvage materials shall not be stacked any higher than the perimeter fence within 75 feet. And that's actually in the provisions of the M2 conditional use provisions. We just want to note that lays out that restriction on the site plan. Then what I had mentioned before, that the site plan comply with the open space area and landscaping material requirements. And that's really their only standard. They don't have any buffer yards or perimeters that they have to worry about here. Any site plan shall identify impermeable paved concrete surface for the dismantling area. If they're going to do anything where they're checking and bringing in appliances and they need to drain any fluids or anything of that nature, they need to designate that area and show it on the plan. And then also that there would be no dismantling of vehicles unless that came back for further consideration. And I don't believe any is proposed, but we do want that put in there so that anyone might be put on notice. Is there any questions? Let me give you I don't believe there was anything on the consent map. If I get it right side up.
Okay. Thank you. Applicant or representative of the applicant?
Did you want me to leave that out there, Ed?
Sure, that's fine.
I just folded it up and I think you might want to use it.
Ed Peltz with Peltz Engineering Company, 2323 Dixon Street, here representing the Seidenfelds and Scrap Processors, Inc., who will be the actual tenant using the outdoor storage site. Just to correct a little bit, this is a future extension that they're looking at. The current outdoor storage would take place along the east edge here, south edge here, and a little bit on the north side of this concrete area. Other than that, we are in complete agreement with city staff recommendations and happy to answer any questions you have.
Does anyone have any questions of the applicant? Thank you. Is there anybody here to speak, any additional person to speak in favor of the application? Is there anybody here to speak against the application?
Why was this not on consent?
Any further
Because we're in litigation with the owner on some other aspects.
Okay.
We're in litigation with the owner, so.
Okay.
We didn't know what we were dealing
Clear
with
enough.
when we took it in, so we
Clear enough.
erred on the side of caution, and it did come in very late, so.
Any further comments by staff?
I did want to, Ed mentioned that this is for future. That would not, because they're showing it here, we would just say any site plan phase would then pave that as necessary if they're going to use that area. So they wouldn't have to come back with their conditional use that you're granting. The concept of this all being used as long as it meets site plan standards is in the conditions that are recommended. So by showing this, they're saying if we start to use this area, we will pave this under the site plan provisions.
And you're accepting of that idea, and they will not have to reapply, is that correct?
Yes,
All
yeah.
right.
I wanted to give you that so that you understood this shouldn't have to come back for that future extension.
Okay. Thank you. We'll close the public hearing and go to board consideration.
I'll move staff recommendations.
Is Is there a second?
Second.
Second.
It's like we don't
It's
need
been
to
moved
wait on
and
this one.
seconded for staff recommendations on item 22. All those in favor signify by saying aye. Aye. All opposed? Matter passes 6-0. The matter of the approval of the minutes for May 23rd, 2012, do I hear a motion?
I'll make motion to approve.
All those in favor, it's been moved and seconded to approve the minutes. All those in favor signify by saying aye.
Aye.
All those opposed, the board minutes are approved 6-0. This meeting is adjourned.
Why, because you forgot to give that to us?